Good morning. I'm Randy Fiorini, Chair of the Delta Stewardship Council, and this is the time and place for the public workshop to receive comments orally and/or in writing on the draft findings of the appeals of the certification of consistency for California WaterFix, which for convenience we will refer to as WaterFix appeals. Let the record reflect that it is 9 o'clock on Thursday, November 15th, and we are here today at the Ramada Inn West Sacramento Conference Center, 1250 Halyard Drive, West Sacramento, California. Council members Mike Gatto, Frank Damrell, and Skip Thompson are present with me for this workshop. Before we begin, I have some general announcements. First, please look around now and identify the exits closest to you. Should an alarm sound, we will be required to evacuate this room immediately. In that event, please take your valuables with you. Second, bathrooms are located out the main doors to my left, your right, and down the hall. Third, the hotel asks that we do not park in hotel guest parking and instead park across the street in the public lot. And last, please silence your cell phones or other devices now. Now, turning to the subject of today's workshop. The 2009 Delta Reform Act granted the Council specific regulatory and appellate authority over certain actions that take place in whole or in part in the Sacramento, San Joaquin Delta, and Suisun Marsh, which are referred to in the Act as covered actions. In order to be a covered action, a plan or project must meet a five-way test, be a CEQA project as defined by law, take place in whole or in part in the Delta, be a public project or be funded or approved by a public agency, be covered by one or more regulations in the Delta plan, and have a significant impact on the achievement of one or both of the co-equal goals or a government-sponsored flood control project. State and local agencies are required to demonstrate consistency with 14 regulatory policies identified in the Delta Plan when carrying out, approving, or funding a covered action prior to initiating the implementation of that action by submitting a written certification of consistency with detailed findings as to whether the covered action is consistent with the Delta Plan. The Council received the certification of consistency for WaterFix as a covered action from the Department of Water Resources on July 27, 2018. It was marked as filed on the same day. 9 appeals of the certification of consistency for WaterFix have been filed, and issues raised by the appeals are within the Council's jurisdiction. We held a public hearing on the Council's review of the WaterFix appeals on October 24th through the October 26th, and have since considered all written and oral comments concerning the WaterFix appeals submitted by October 26th. Thank you for the input, and I want to especially thank those that were in the audience for the respect and courtesy extended at the October hearings. Near the close of the hearing on October 26th, I directed staff to prepare draft findings based on the materials submitted by the parties and taking into consideration the comments received over the course of the hearing. I asked staff to present those draft findings to us at today's workshop. Those findings were posted on our website and shared to the listserv and service list on Thursday, November 8th. We will consider the oral comments received during this workshop and written comments received through next Monday, November 19th by 5 p.m. on staff's draft findings regarding the WaterFix appeals. I want to be clear that we will not be taking any action at this workshop. Instead, we will hold a public hearing during the Council's December meeting on December 20th and 21st if needed. Following this final hearing, we anticipate adopting findings and either denying the appeals or remanding the certification of consistency for WaterFix project back to the Department of Water Resources. The public hearing in December will be publicly noticed soon. Let me also remind you that the scope of the council's review is limited to whether or not the certification of consistency was supported by substantial evidence in the record before the Department of Water Resources when it was submitted. Today, or ultimately, it will not be a vote based on policy preference. As a reminder, given the adjudicatory nature of the appeal before the council, all council members and staff are under an ex parte communication prohibition. This means until we reach a final decision on the WaterFix appeals, council members and staff are not available to comment or receive comments on matters at issue here in the WaterFix proceedings outside of a noticed public meeting such as the workshop today. To those representing the Department of Water Resources, the Delta Protection Commission, appellant groups, and members of the public here today to comment on the WaterFix appeals, here are some important instructions. Commenters speaking today will not be sworn in. This entire workshop will be recorded by a certified court reporter. The rough transcript of the hearing and all written materials presented during the hearing will be shared with the listserv, with the service list, and posted on the council's WaterFix website in approximately 2 weeks. If you're interested in purchasing final transcripts from the reporters in the interim, please coordinate with them directly. California Reporting is represented today by Candace Yount, seated to my right, and California Reporting can be reached at 510-224-4476, or you can see Candace during a break. We will be taking 15-minute breaks each morning and afternoon, as well as a 1-hour lunch break. As with all public council meetings, this meeting is being webcast on the internet, and the audio and video will be available for later review. We will first hear from staff, who will walk us through their draft analysis and recommended findings. We will then hear from the Department of Water Resources. Next, the appellant groups will be heard in order of the appeal number from Appellant 1 through Appellant 9. We will then hear from the Delta Protection Commission. Upon completion of all presentations, we will commence with public comment. The department, the respective appellant groups, and the Delta Protection Commission will each be allowed 15 minutes for oral presentations. Some appellant groups have asked to consolidate their time. We have approved North Coast River Alliance, Appellant Group A1, ceding its 15 minutes to San Joaquin County, Appellant Group A7. San Joaquin County will have their presentation, 25-minute presentation, ceding 5 minutes to save the California Delta Alliance, Appellant Group A2, a 20-minute presentation. In the City of Stockton, Appellant Group A5, and Sacramento Regional County Sanitation District, Appellant Group A6, will have a combined 30-minute presentation. If my explanation is not clear, it will become clear as we proceed through the presentations. No additional requests will be accepted. Council members, I'd encourage you to hold your questions for presenters speaking until the conclusion of their respective presentations. At that point, I will open the opportunity for council member questions before proceeding on to the next party. When the presentations portion has ended, we will proceed to receive public comment. Any other interested parties who want to provide public comment will be allowed 3 minutes for oral presentation. Additional time will be allowed if there are any questions by council members or council staff. If you want to provide public comment and are not a speaker on behalf of one of the appellant groups, the Delta Protection Commission, or the Department of Water Resources, we ask that you fill out a blue speaker card available from our clerk, Lita Brighty, seated over here. The cards are marked in groups designated A, B, C, and so on. Your comments will be heard in the group order we received the completed blue speaker cards. Given the number of parties and the time allotted to each, we anticipate that public comment for all other interested parties will begin tomorrow at 9 o'clock. So for certainty's sake, we will reconvene tomorrow at 9 o'clock. But that's an estimate in terms of when public comment may start. If the presentations end early and there's time for public comment this afternoon, we will accommodate members of the public who are here today. For scheduling certainty for people in this room and for those watching on the website, we will also, as I've said, reconvene tomorrow in this room at 9 o'clock for public comment. After we hear from everyone who has filled out a blue speaker card, we will close the public comment portion of the workshop and hear from council members. Please keep in mind when providing comments today that the scope of the council's review is limited to whether or not the certification of consistency is supported by substantial evidence in the record before the Department of Water Resources when it was submitted. When you come to speak, we ask that you do a couple of things so that the council, audience, and the court reporter may hear you, and so that your comments are entered into the record and can be responded to appropriately. First, please speak into the microphone, and second, please begin by stating your name and identifying your organization if you represent any. Finally, there is a 3-minute timer, or it will be 3 minutes, and when public comment starts, located at the end of this table. Please respect the 3-minute time allowance. That concludes my introductory comments, albeit lengthy. At this point, I would like to call on our Executive Officer, Jessica Pearson, to proceed with the staff's presentation.
Thank you and good morning. Given the scope of the matter before us, I'll keep my remarks brief. As stated in the notice, the purpose of this workshop is to provide an opportunity for the council, parties, and the public to provide input on the staff's draft recommended findings. To that end, throughout the day today, staff will be available to the council to answer questions and discuss potential modifications. This is also your opportunity to seek information or clarification from the department, the Delta Protection Commission, and appellants on the issues at hand. What we ask of you, council members, at this workshop is clear direction regarding any proposed modifications and direction to prepare a proposed determination for your consideration and a decision in December. Given the complexity of the task and the relatively short amount of time afforded for such a review under statute, I'd like to acknowledge my sincere appreciation for council staff for their tremendous effort to this point. I'm proud of their work, and I take responsibility for any errors. To the extent there are errors, it's my hope today that we improve the draft based on the discussion. As Chair Fiorini stated, no decision will be made today, but the council will be asked to vote on a final proposed staff determination in December. I look forward to a productive discussion, and now I'll turn to Jeff Henderson, who's our Deputy Executive Officer for Planning, for presentation of the staff's recommended findings. Thank you.
Good morning, Chair, council members. It's my privilege to present the staff recommendation to you on behalf of your staff and the great efforts of the folks who are sitting behind me today. By way of overview, today's presentation is going to cover the Council's covered action authority and process, and Chair Fiorini summarized much of that in his opening remarks. We'll provide a summary of the staff report that's been prepared in the staff draft determination that's before you today. And then we'll outline our analysis and the draft recommendation that's before you. By way of summary, that recommendation is that staff recommends that the council conclude that substantial evidence does not exist in the record to support a finding of consistency for this project. And then staff recommends that the council remand that matter back to the department for reconsideration. And we'll outline the reasons behind that staff recommendation throughout our presentation. To touch briefly on the council's authority, this stems ultimately from the 2009 Delta Reform Act, which is the state's policy regarding how to achieve the co-equal goals. And that act, through statute, granted the council certain regulatory and appellate authority over covered actions. The Delta Plan is ultimately the document that presents the regulatory policies that are used to meet the objectives that the legislature said were inherent in the co-equal goals. And that covered action authority granted to the council from the Delta Reform Act requires state and local agencies to demonstrate consistency with Delta Plan policies when carrying out, approving, or funding covered actions, and that documentation is to occur prior to implementation. Documenting consistency with the Delta Plan is addressed through what's known as a certification of consistency. A project proponent ultimately determines if a project is a covered action, and those covered actions then require written certification to the council accompanied by detailed findings. Once a certification is submitted, any person who claims a covered action is inconsistent with the Delta Plan may file an appeal of that certification within 30 days. The appeal must include specific factual allegations that help to define what it is that the council considers with regard to the appeal. And certifications and appeals for all covered actions are noticed and listed on the council's website. Once an appeal is received, the council is obligated to conduct a hearing on the appeal within 60 days of filing. And within following that hearing, the council must make a decision regarding the appeal within 60 days of conduct of the hearing. There are essentially two options with regard to the determination. The first being to deny the appeals, under which case the project may proceed. The second being to remand the project to the proponent for reconsideration. It's important to note on appeal, failure to demonstrate consistency on one policy may result in the remand. During the hearing, the department provided an extensive description of the project before us today, namely California WaterFix. By way of summary, the WaterFix project includes physical improvements to the state water project, including three new North Delta intakes, expanded South Delta intakes, and underground tunnels that connect the two. The project would enable the state water project to operate using dual conveyance, providing diversions from the North Delta, as well as option to divert from South Delta intakes under certain conditions. It's important to note that the project that the department has certified as consistent with the Delta Plan is California WaterFix as described in the 2017 final EIR-EIS approved by the department. It's worth noting that there are several other overlapping review and approval processes that are also underway. These include a draft supplemental environmental impact report, environmental impact statement, analyzing proposed project refinements that is currently being processed by the department. It also includes the State Water Resources Control Board hearings on the change in point of diversion for WaterFix, which is ongoing, and also includes the State Water Project contract amendments and extensions. All of these are separate parts of the overall process, but connected to the project. But these are not part of the certification that the department has submitted to the council for consideration at this time, and features of these projects generally are not considered in the certification. The department's certification was posted to the certification was posted on the department's website on July 17th and then submitted to the council on July 27th of this year. The certification provides background and descriptive information about the project. It offers detailed findings for each Delta Plan policy and cites portions of the record that the department offers as substantial evidence to support its certification. And again, the certification is available on the council's website. The table before you identifies essentially the department's certification relative to each of the Delta Plan's regulatory policies. There are 17 regulatory policies in the Delta Plan, technically 14, one of which has 4 parts, thus the 17. And the department's finding for 14 of the 17 policies is that WaterFix is consistent with the relevant policy. The department's finding for 3 of the 17 policies, as indicated in the table, is that those policies are not applicable to the California WaterFix project. Moving to the appeals, We received 9 appeals, 9 appellants submitted timely appeals, which were deemed filed on August 27th of this year. The appeals included numerous challenges to the department's certification related to 12 of the Delta Plan policies. It included also some general CEQA and legal issues. The appeals included assertions that the council's consideration of the certification is premature. The appeals also included numerous requests to supplement the department's record on the matter, and all of the appeals are also available on the council website. The slide before you, it identifies the individual parties that submitted appeals or the groups that submitted appeals and the specific Delta Plan policies that their appeals implicate. We've heard a bit about substantial evidence in the opening remarks. I'd just like to remind again that the scope of the council's review is whether the certification is supported by substantial evidence. It's important to note that substantial evidence consists of facts, reasonable assumptions based upon facts, and expert opinions supported by facts. Substantial evidence does not include argument, speculation, unsubstantiated opinion, or evidence that is erroneous or inaccurate. And our attorneys are available today to the council to address any questions concerning substantial evidence as they apply to the individual policies in question. It's important also to note that the council's review and council staff's analysis and findings are essentially occur within a fairly precise frame. That frame consists of the project that's submitted by the department, the issues that are raised on the appeal or appeals, and the substantial evidence in the record. The council does not independently review the project to determine if the project is consistent with the Delta Plan, but the council does determine if substantial evidence in the record supports the department's certification that the project is consistent with the Delta Plan, and that occurs in light of the appeals. So again, just trying to really illustrate that frame that the analysis is based on the project as it's submitted by the department, the issues that are raised on the appeals, and the substantial evidence in the record. Concerning the record, the department certified its record as full and complete on September 7th, 2018. The record itself contains more than 26,000 individual documents, and several recommended additions to the record are described in the staff draft determination based on standards identified in the council's administrative procedures for appeal. This slide outlines the number of different types of documents that comprise the record. Suffice to say, the record is voluminous. Staff has not reviewed every part of every document, and it is ultimately the department's responsibility to show in the certification what part of the record supports the certification. In turn, it's the appellant's responsibility to describe specifically where in the record there may be a potential issue. And these, again, are the framework that we've used to complete our analysis. The Delta Protection Commission has a very important advisory role in council proceedings. And that advisory role stems from Public Resources Code section 29773, which states that the commission may review and provide comments and recommendations to the council on projects that are within the scope of the Delta Plan, including projects that affect Delta as place issues. The council's procedures for appeal additionally invite the commission to address the council regarding appeals during public hearings. The commission submitted comments and recommendations to the council on October 16th of this year concerning this matter, and the staff draft determination before you considers the commission's comments and recommendations as they're related to issues that have been raised by appellants. Chair Fiorini noted the hearing that occurred on October 24th through 26th in this room. At that hearing, the department, appellants, the commission, and other persons all provided testimony to the council concerning the certification and appeals. And that testimony, as it applies to the appeal issues under consideration, is addressed in the staff draft determination before you. Regarding the staff draft determination, the workshop that we're hosting today was noticed on October 29th of this year, and the staff draft determination was released 1 week ago on November the 8th. The draft determination includes staff's analysis and findings regarding the appeals that are based on the record and information offered at the hearing. Today's workshop is an opportunity for the council to discuss, or for council members to discuss, and offer direction to staff regarding our recommended findings. There is a public comment period open for the staff draft determination that will run through noon on Monday, November 19th, and final council action on this matter is anticipated following a hearing in December. That hearing has yet to be noticed, currently planned for the December council meeting, which is December 20th and 21st. Stepping into the draft findings, the first matter that we'd like to address is a number of appellants have asserted that the timing of the department's submittal of the certification of consistency is premature. And much of that is based on, again, the related activities that we touched upon earlier, including the draft supplemental EIR/EIS on project modifications that were identified last spring, future operations of the Central Valley project and Reclamation's future participation in the project, ongoing change in point of diversion hearings at the Water Board, and the State Water Project contract amendments and extensions. Each of these may result in future changes to the project that's before you for certification today. Staff's recommendation regarding this matter is that staff recommends a finding that the timing of the certification is not legally premature. What staff does recommend in this matter is an early and robust consultation going forward to determine if proposed changes resulting from these or other matters would result in new covered actions that may be subject to a certification of consistency. With regard to the individual policies and the analysis of consistency with those policies, the table before you now presents a summary of staff's draft findings concerning those matters. We're presenting these in a slightly different order than is presented in your staff report and the determination, and it's because we've essentially grouped them by outcome for ease of reference. For 3 policies, the staff recommendation is that the council determine that the policies do not apply to California WaterFix. Those are indicated in this table by NA under the column substantial evidence supports the department's certification. For 4 policies, staff's recommendation is to deny the appeals related to those policies. Those are indicated in this table by yes under the right-hand column. In these cases, staff's recommendation is the finding that appellants fail to demonstrate that the department's certification is not supported by substantial evidence. For 5 policies, the staff recommendation is to remand the project concerning consistency with the individual policies. These are marked by no in the right-hand column on the table before you. On these issues, staff's recommended finding is that the department fails to demonstrate substantial evidence in the record to support its findings. For each policy, the balance of our presentation today will summarize the content of the department's certification, the key issues that are raised on appeals, staff's analysis, and staff's conclusion and recommended finding. So we'll step through the individual policies in order. The first grouping, and we essentially have put them in the 3 groups described previously on the previous slide. The first group are for the policies where staff's draft findings, recommended findings, are that the policies do not apply to California WaterFix. These include policy WRP2, which is our policy requiring transparency in water contracting, Ultimately, staff's recommended finding is that the contract amendments that are associated with WaterFix but not a part of the project before you today are outside of the certifications project scope, but may be future covered actions and should be addressed with council staff as they proceed. The second is policy ERP2, which is our policy requiring restoration of habitats at appropriate elevations. Ultimately, in the department's certification, it's determined that it's not possible at this time to determine the elevation proposed for each restoration site that may be required as mitigation associated with the project. And for that reason, it's not possible to analyze the consistency of those sites with the policy, with a notation that future restoration activities resulting from the project may themselves be covered actions and subject to future certifications with the council. The third of the policies that we recommend a finding that the policy does not apply is RRP1, our policy for prioritization of state investments in delta levees and risk reduction. Ultimately, this policy applies to covered actions that are discretionary state investments and flood risk management projects. And ultimately, the staff's recommended finding is that the proposed project here is neither of those, and therefore the policy does not apply to California WaterFix. As we move to the second group of staff draft findings, this is a group of 4 policies, essentially, where staff recommends that the council deny appeals because appellants fail to demonstrate that the department's certification is not supported by substantial evidence. On these policies, we'll walk through an individual discussion of each. The first is policy GP1B2. This is a policy that requires, it applies to projects that are not exempt from CEQA and requires inclusion of applicable feasible mitigation measures that are equal to or more effective than mitigation measures that are described in the program environmental impact report that was prepared for the Delta Plan upon its adoption. The department's finding with regard to this policy is that the WaterFix project is consistent with the policy. The department provides a crosswalk between the WaterFix mitigation measures that are proposed as part of that project's environmental impact report, environmental impact statement, and the mitigation measures that are proposed, that are adopted as part of the program environmental impact report for the Delta Plan. The key appeal issues included challenges to sort of more traditional CEQA challenges to mitigation regarding potentially mitigation being vague or unenforceable or deferred, but also included challenges to the equal to or more effective standard described in the policy using example measures that are pulled from the WaterFix project EIR. And it's worth noting that mitigation measures in this context includes mitigation measures included in the EIR, as well as environmental commitments, avoidance and minimization measures, and other commitments that are a part of the project description itself. The staff analysis regarding this policy is that appellants do not identify while appellants identify potential examples of inconsistent measures, they do not identify measures that fall short of the Delta Plan's equal to or more effective standard. The department in all cases cites to enforceable mitigation measures in the FEIR EIS, as well as a commitment to implement those measures prior to construction. For a number of these measures, the time frame associated with the measure is that it be completed prior to construction, not necessarily that it be completed at the point in time of certification. For these reasons, our recommended conclusion here is that the appellants failed to demonstrate that the certification is not supported by substantial evidence. As we move to the next policy, I'll ask Dr. Callaway to summarize our findings relative to adaptive management.
Thank you, Jeff. So for adaptive management issues, this is policy GP1B4, and it requires that covered actions related to ecosystem restoration and water management includes adequate provisions to support adaptive management and that these adaptive management efforts are appropriate with the scope of the covered action. In particular, this policy requires an adaptive management plan that describes the approach to adaptive management for a covered action, and this plan must be consistent with the framework that's outlined in Appendix 1B of the Delta Plan. The appendix identifies the three broad phases of adaptive management: the plan, do, and evaluate phases, and the more detailed 9 steps that are a part of the adaptive management wheel that the Council has developed. Second, the policy also requires documentation of adequate resources and specific delineated authority to implement the proposed adaptive management process. So in their consistency document, the department finds that it is consistent with both aspects of the adaptive management policy, having an appropriate adaptive management plan and documenting the resources to implement the plan. As part of its detailed findings in support of this, the department submitted the proposed Project-Wide Adaptive Management Program, or PAMP, for California WaterFix. And it's important to note that the PAMP includes the earlier Biological Opinion Adaptive Management Program, which you'll see referred to as the BIOP AMP. And then beyond this, the PAMP also identifies additional adaptive management efforts to address uncertainties associated with the implementation of mitigation measures, with environmental commitments, and with avoidance and mitigation measures, all of which are included in the Mitigation, Monitoring, and Reporting Program for the California WaterFix Final EIR-EIS. Appellants raise issues on both aspects of the adaptive management policy, providing a plan as well as documentation of adequate resources. In evaluating these claims, the staff found that for the first issue, the consistency with the appendix and the framework for adaptive management, appellants raise a number of general issues, but these claims are not tied to specific policy requirements regarding adaptive management. So, as an example, multiple appellants raise issues regarding the lack of enforceable triggers or criteria for adaptive management. That these are not included in the plan. However, there are no requirements in Appendix A1, the framework for those specific components of an adaptive management plan. Appellants also raise issues around the deficiencies identified in the adaptive management program for the biological opinions. However, these issues that are raised around the BIOP AMP are addressed in the subsequent PAMP, and so those really are covered. Appellants also raise questions whether adequate resources were identified for the adaptive management program. In evaluating the record, staff found that the department has provided substantial evidence that does document that adequate resources and delineated authority are provided. So given this, in the analysis of the policy, the staff recommends that the appellants fail to demonstrate that the certification is not supported by substantial evidence. Jeff.
Thank you. I'll now turn to Dan Constable to summarize our recommended findings concerning several policies addressing ecosystem restoration.
Thank you, Jeff. Good morning. Policy ERP3 requires projects to avoid or mitigate significant adverse impacts to the opportunity to restore habitat and establish priority habitat restoration areas, which are described in the Delta Plan. The department's finding is that it is consistent with this policy. Appellants assert that evidence does not support the department based on 3 primary areas. First, that infrastructure and construction will contaminate habitat and the construction period will limit restoration opportunities. Secondly, that the mitigation measures proposed rely on future plans that are yet to be developed. And lastly, that the project will reduce freshwater flows through the delta and that this in turn will negatively impact restoration opportunities. Staff's analysis is that the department cites to evidence in the record that supports its finding. Specifically, the department describes how concrete batch plants and fuel stations will be temporary and will be removed. It describes performance standards that will be developed for future plans, and it also describes or notes that appellants do not cite the detailed findings explaining how the project would preclude restoration opportunities, for example, due to the alleged reduction in freshwater flows. And for these reasons, our recommendation is that the appellants fail to demonstrate that the department's certification is not supported by substantial evidence. Next, I'd like to go through policy ERP5. This policy requires that introductions of or improved habitat conditions for non-native invasive species be fully considered and avoided or mitigated. The department finds that they are consistent with this policy and cites to evidence in the final EIR, EIS, and enforceable mitigation measures in other actions and programs that would address this. The appellant on this policy asserts that construction is likely to introduce or disperse invasive species and that the mitigation proposed is insufficient or misplaced. Staff note that the department does acknowledge potential opening of habitat to invasive species. However, the department also cites to enforceable measures that are supported by substantial evidence in the record. In addition, for some assertions, the appellant makes only general claims that are not tied to ERP5's requirements. And for these reasons, staff recommend a determination that the appellant fails to demonstrate the department's certification is not supported by substantial evidence.
Thank you, Dan. So we'll now move to the third group of staff draft findings related to the policies. This is a group of 5 policies that form ultimately the basis of the staff recommendation to remand the project. And this is a group of findings for which the recommended finding is that the department fails to demonstrate substantial evidence in the record to support its findings in the certification. And we'll begin with Dr. Callaway summarizing our findings relative to best available science.
Great. So with regards to best available science issues, the Delta Plan requires that all covered actions must document the use of best available science. And this requirement is expanded upon in Appendix 1A of the Delta Plan, which identifies the 6 criteria that are used to evaluate best available science and that are illustrated here on the slide. And these criteria are also summarized on the next slide. So in their certification of consistency, the department stated that the project is consistent with all of these 6 criteria that are required for best available science. Related to relevance, they identify that they used a wide range of sources that are germane to the Delta ecosystem and the physical and biological components of interest. In terms of inclusiveness, these sources came from a wide range of disciplines. For objectivity, they used non-biased analyses. In terms of transparency and openness, they incorporated public review and input. For timeliness, they identify that they used up-to-date information in their evaluation of the project. And for peer review, they used peer-reviewed literature and processes throughout. 6 appellants raised a number of issues regarding best available science, and we've organized these appeals into 4 major areas that are identified here on the slide, along with the specific criteria for best available science that were raised for each of these issues, and that's shown in bold on the right side of the slide. In terms of modeling claims, these focused on the adequacy of the modeling analysis that was completed, primarily considering hydrologic and water quality modeling. There were broad issues that were raised regarding missing content within the final EIR. The appellants claimed that the information that was considered was not inclusive or had some bias. Questions were also raised regarding the impact analysis that was completed for harmful algae and microcystis, for salinity effects on agriculture, for impacts to sandhill cranes, and impacts to air quality. And then finally, questions were raised regarding the approach that was used to evaluate future sea level rise projections, focusing on the lack of incorporation of more recent science regarding sea level rise or the timeliness of the science that was used. So for the first 3 issues, staff analysis concluded that the appellant's claims were not supported by the record. In terms of the modeling issues, appellants questioned the hydrologic models that were used, namely CalSim-2 and DSM-2. But no better alternatives were identified by the appellants, and the department provides evidence in the record to support that these are best available science. In terms of missing content, the issues that were raised were broad and lack specific information relating the issues to the particular criteria that are used to evaluate best available science. So given this lack of specificity, there's no basis for the staff to evaluate the issues that are raised, and these appeals are not supported. And then similarly, for the adequacy of impacts analysis, a clear link to the best available science policy is not supported in the appeals. Furthermore, the department cites to the record showing analysis of impacts that have been performed using appropriate methods and best available science. So as I mentioned, for each of those cases, the staff concluded appellant's claims are not supported by the record. For the last issue, in the case of sea level rise, the appeal was raised that the department did not consider current recommendations for future sea level rise projections and therefore did not consider timely and appropriate science. In particular, the department's sea level rise modeling does not consider higher rates of sea level rise over longer time horizons. Approaches that are appropriate for high-risk scenarios as recommended in reports by NOAA in 2012 and by the California Ocean Protection Council earlier this year. Rather, the sea level rise scenarios that were considered would be appropriate for low-risk projects like a coastal trail, but are not appropriate for infrastructure with a long life cycle. While the department indicated at the hearing last month that sensitivity analysis had been completed to consider higher risk scenarios, staff at the council could not find evidence in the record for modeling or sensitivity analyses that considered these higher risk scenarios beyond 2060. So as indicated on the slide, based on the issues of timeliness for sea level rise projections, staff recommends that the department's certification that its sea level rise modeling reflects the best available science is not supported by substantial evidence in the record.
Thank you. We'll now turn to Ryan Stambra to summarize our approach to policy WRP1.
Thank you, Jeff. WRP1, the reduced reliance policy, states that Delta water shall not be exported, transferred, or used if all of the following conditions apply. The project would have a significant adverse environmental impact in the Delta. One or more water suppliers that would receive water from the project has failed to contribute to reduced reliance as demonstrated through urban or agricultural water management plans that include quantitative data demonstrating a measurable reduction. And finally, the failure by at least one water supplier to reduce reliance has caused the need for the project. If one or more of these conditions are not applicable, the project is consistent with WRP1. For the purposes of this policy, staff analyzed three aspects. The first, does WRP1 apply to this project? The second, does substantial evidence support the department's finding of consistency with WRP1? And third, if substantial evidence is found to be lacking to support the department's finding, is the project nevertheless consistent with the co-equal goals under policy GP1B1? Turning to the first issue, does WRP1 apply to this project? In its certification, the department states that WRP1 only applies to a new water export, transfer, or in-delta water use project. Therefore, the department contends that since California WaterFix does not propose new exports and would instead amend existing water rights for the 3 new points of diversion, WRP1 could be interpreted as not applicable to the project. Multiple appellants, however, dispute the department's assertion, stating that such an interpretation would not reduce the current reliance of water suppliers on the Delta. Council staff finds that nothing in WRP1 suggests that the application of the policy should be limited to a new or expanded water right. Therefore, staff recommends that WRP1 applies to California WaterFix. Moving on to the first component of WRP1, and whether the project would have a significant adverse environmental impact on the Delta. In its certification, the department contends that the project would not have such an impact, citing that there would be no significant change in the amount of water exported from the Delta. However, in its responses to hearing questions, the department does acknowledge that criterion for A3 has been met. Appellants challenge the department's initial contention that the project would not have a significant impact and take issue with not only the department's export projections, but also the department's conclusion that the amount of water exported would ensure that the project would not have a significant impact on the Delta. Council staff is recommending that A3 does apply to this project as substantiated by the department's response to the hearing questions in October. The second component to consider is the reduced reliance provision. and whether one or more water suppliers receiving water as a result of this project has failed to reduce reliance on the Delta. In its certification, the department provides extensive information for some water suppliers, as well as a qualitative explanation for how some agricultural water suppliers have reduced reliance. The department also recognizes partial compliance with this particular policy component, stating that certain aspects of the reduced reliance provision, such as the implementation of actions noted in water management plans and quantifying measurable reductions in plans, is neither feasible nor required. In other words, the department contends that the three elements of the reduced reliance provision in C1, which is in the lower left-hand side of the slide, are but one way to demonstrate reduced reliance. Multiple appellants note that strict interpretation of the policy is required and emphasize the WRP1 requires all water suppliers to have done all of the elements required under C1. Council staff interprets the reduced reliance provision and its associated elements as required. WRP1 in staff's view does not provide for an alternative pathway for demonstrating reduced reliance, nor does it allow for partial compliance. Therefore, the department's information is incomplete and lacks the quantitative elements necessary to substantiate reduced reliance. As a result, council staff is recommending that A1, the reduced reliance provision, is applicable to the project. The third and final component of WRP1 to consider is whether the failure to reduce reliance by one or more water supplier significantly caused the need for the project. The department contends that the need for the project was not significantly caused by a failure to adequately reduce reliance. Instead, the department asserts that the need for the project was caused by factors that predate and exist independently of the reduced reliance policy, such as the decline of fish populations in the Delta, leading to reduced pumping and less reliable water deliveries. Appellants dispute this conclusion, stating that the need for the project is directly the result of a failure to reduce reliance by one or more water suppliers. The council staff recommendation is that absent complete and quantitative data required in the reduced reliance provision A1, which we previously discussed, the department cannot properly analyze whether the failure to reduce reliance caused the need for the project. As a result, council staff recommends that A2 is also applicable to this project. So in conclusion, council staff finds that based upon substantial evidence in the record, the project meets the criterion of all three provisions in WRP1, and therefore the department's finding of consistency with WRP1 is not supported. And since the staff recommendation is that the project's consistency with WRP1 is not supported, staff further assessed whether the project is nevertheless consistent overall with the co-equal goals. Recognizing that full consistency with all Delta Plan regulatory policies may not always be possible, the Delta Plan includes policy GP1B1, which enables the project proponents to be inconsistent with a specific policy, but on the whole, consistent with the co-equal goals. Such a determination requires explanation as to why consistency is not feasible and how the project nevertheless is consistent with the co-equal goals. At the October hearing, the department stated that it was invoking GP1B1 for policies DPP1 and WRP1. For WRP1, the department does not contend that reducing actual reliance is infeasible, but rather that demonstrating reduced reliance in the manner required by the reduced reliance provision is infeasible for three reasons. First, the department contends that compliance with the reduced reliance provision is infeasible because water management planning laws do not require water suppliers to include reduced reliance elements. The second point the department raises with regards to infeasibility is the department's lack of legal authority to require water suppliers to include quantitative data illustrating reduced reliance in their water management plans. Finally, the third point that the department raises is that the quantitative data required under the reduced reliance provision is not required to be included in the 2015 water plans. Therefore, information does not exist in the format required by WRP1. In response, appellants contend that the lack of statutory requirement does not prohibit water suppliers from including the required information in WRP1. The lack of the department's authority does not excuse water suppliers from providing the required information. And while compiling the data required under the reduced reliance provision in the manner necessary may have required significant time and effort, that alone does not demonstrate infeasibility of the project complying with WRP1. For the reasons stated by the appellants, council staff's recommendation is that the department has failed to identify where consistency with WRP1 is not feasible, and as a result, it's also staff's recommendation that the council need not consider whether the project is consistent overall with the co-equal goals.
Thank you. We'll now turn to Dan Constable to summarize our approach to delta flow objectives.
Thank you, Jeff. Turn to policy ERP1. This policy requires demonstration of consistency with the State Water Resources Control Board Bay Delta Water Quality Control Plan as described by Water Rights Decision 1641, which is also referred to as D 1641. The department finds that they are consistent with ERP1 and relies on two broad areas of evidence in support of its finding. First, modeling of future operations, and secondly, historical compliance with D 1641 and its predecessor, D 1485. Appellants raise a number of assertions on these same two areas. For modeling, appellants assert that the department has modeled compliance using different criteria for the export inflow ratio than is required by D 1641. In addition, appellants also assert inconsistency with a range of additional issues, such as how Rio Vista flows are considered in modeling, operation of the Delta Cross Channel, or DCC, how models have been downscaled in some instances, and compliance with D 1641 if the delta were to experience widespread levee failure. For historical rates of compliance, appellants assert that the calculation of the compliance rate includes periods of permanent relaxed standards, such as when a temporary urgency change petition, or TUCP, was in effect, and that the compliance rate is calculated by combining different compliance locations in multiple years. Staff's analysis of modeling and planned operations examined areas raised by appellants, which focuses on evidence related to export inflow ratio. D 1641 requires a specific ratio between exports from and inflows to the delta and specifies where these must be measured. As defined under D 1641, inflow is calculated based on a number of inflow locations, including at Freeport on the Sacramento River, which is shown in red on the circle here in the slide. This is upstream of the proposed North Delta diversions and the location where the department has modeled inflow downstream of. And the diversions are shown here in a blue or darker circle on the slide. Similarly, D 1641 also defines how exports must be calculated as the combination of inflows into Clifton Court Forebay and exports from the Tracy pumping plant. We also note the department cites to a sensitivity analysis for modeling the effects of using different compliance point locations. However, the scenario cited to is not for the exact operations proposed for WaterFix and does not show the effect on other standards beyond the export inflow ratio, so the evidence on its own does not alternatively support the department's finding for the export inflow locations. Lastly, on this issue, the department describes why it has selected alternate compliance points. However, regardless of the justification, council staff cannot speculate as to the location of potential future compliance points that may be changed by the Water Board. Rather, we are limited to the definitions as currently described in D 1641. For a number of other assertions that I mentioned on the previous slide, such as the role of reclamation or operation of the Delta Cross Channel, the department does cite to evidence that supports its finding, and these are further described in the draft determination. Turning to the historical record, staff considered evidence cited to by the department and its finding that it can avoid future exceedances through real-time operations. Appellants assert and staff note that the reported compliance rate includes periods of permanent relaxed standards, such as when a temporary urgency change petition, or TUCP, was granted. While TUCPs are allowed under Water Code, citing to evidence that the department can comply with the standards in TUCPs does not necessarily support an ability to comply with D 1641. Secondly, the compliance rate is based on an approach that counts as days of compliance any day on which water quality met one of the applicable standards on that day. However, this does not equate to evidence of compliance with D1641 on its own. For example, if there were 10 standards in effect on a given day and 9 were met, this could be considered as 90% of time in compliance. However, from the evidence presented, staff cannot analyze if a similar compliance rate may have been 9 different days in compliance or a single day with 9 standards in compliance. So, based on the above points, staff's analysis is that the evidence cited to by the department does not support its finding with regards to modeling or reliance on the determination historical record, and therefore our recommendation is that the department fails to support its finding with substantial evidence.
Thank you. I'll now summarize staff's analysis relative to policy DPP2, the policy to respect local land use when siting water or flood facilities or restoring habitats. This policy essentially requires that water management facilities must be sited to avoid or reduce conflicts with existing uses and city and county general plans when feasible, considering comments from local agencies and the Delta Protection Commission. The department's finding relative to this policy is that the WaterFix project is consistent with policy DPP2. 6 parties appealed that consistency determination, identifying 11 issues related to the certification of consistency. I'll note a great deal of the determination is devoted to these issues. And I'll ask those following along in the presentation to go ahead and skip forward to slide number 48. There was simply an additional slide in the packet that's not in the presentation. Oh, hang on one second. I want to highlight some distinctions between CEQA and policy DPP2. Ultimately, CEQA requirements, many parts of our regulatory process are extensions of the California Environmental Quality Act. And as a result, considerable portions of the certification and the record rely on CEQA and the department's environmental impact report, environmental impact statement for California WaterFix. There are several ways in which the requirements for CEQA are different than those for policy DPP2. State agencies are not normally subject to local land use regulations. However, Delta Plan regulations, including DPP2, apply to state agencies. Specifically, DPP2 applies to siting water management facilities, ecosystem restoration, and flood management infrastructure, and requires siting to avoid or reduce land use conflicts when feasible. In CEQA, land use conflict is not necessarily an environmental impact, and social and economic impacts must have significant environmental physical effects to be considered. DPP2 is different from CEQA in that it focuses on existing and planned land use conflicts, which is a concept that is fundamentally different from environmental physical impacts. In CEQA, significant environmental physical impacts must be mitigated to the extent feasible, and significant and unavoidable impacts may remain after mitigation. DPP2 requires that conflicts be avoided or reduced when feasible, considering comments from local agencies and the Commission. This means that for DPP2, our draft findings were based on substantial evidence as it relates to whether the conflicts were avoided or reduced when feasible. These distinctions are acknowledged by the department during the October hearing and supported by comments from the Commission. In summary, DPP2 offers enhanced protections and considerations for Delta land uses and communities for facility siting and the resulting effects. 11 issues, as I indicated previously, were identified by the appeals, including conflicts with local land use plans, conflicts with existing Delta communities, a range of environmental effects resulting from land use conflicts, indicated here by items C through J in the table, and consideration of comments from reclamation districts. For 5 of these issues, staff's recommendation is to deny the appeals based on appellants failing to demonstrate that the department's certification is not supported by substantial evidence. For 6 of these issues, staff's recommendation is to remand the project. And in these cases, the department fails to demonstrate substantial evidence in the record to support the findings. And again, as with the previous table, those items where we're recommending denying appeals are indicated by yes, and those items where we're recommending remanding the project are identified by no. For 5 topics, staff's finding is that the record supports the department's certification for DPP2. Given the importance and the nuance of our findings related to agricultural impacts, I'd like to highlight our recommended findings on that matter. The evidence in the record shows how the mitigation measures and commitments that the department identifies would reduce or avoid conflicts with agricultural uses. These include such things as the reduction of the overall footprint of agricultural conversion of the project through refinements over the years that have led to the current project before the council. And for agricultural conflicts that are unavoidable, the Mitigation and Monitoring and Reporting Program identifies an Agricultural Land Stewardship Plan program. The agricultural land stewardship plans would be developed between the project proponents, so the department, and landowners, and would involve local and regional interests, including local government and potentially the commission and the council, to further reduce or avoid potential conflicts. These are essentially voluntary agreements. If an ALSP with a landowner and the other parties cannot be reached for some reason, if the consensus around that cannot be reached, traditional one-to-one land mitigation through agricultural conservation easements is required by the mitigation if it's feasible. Ultimately, our finding is that the ALSPs are a preferred approach or a stronger approach to the traditional one-to-one mitigation associated with ag land conversion, given the unique constraints within the delta on the availability of land suitable for conservation easements. And it also allows for specific characteristics of individual properties that could be affected to be taken into account. This we do, though, want to contrast with our findings regarding the socioeconomic impacts of lost agricultural production on delta communities. And on that matter, staff's recommended findings do not support the department. For 6 issues, the record we'll recall that previous comments that DPP2 focuses on conflicts with land use plans and existing uses, which are created at times by Sql Impacts as well as other factors. For 6 issues, the record does not support the finding that the department reaches regarding consistency with policy DPP2. For non-Sql conflicts, reduction and avoidance measures generally are not proposed, and no evidence is cited that provides detailed information about the proposed Community Benefits Fund, including that it constitutes an enforceable commitment. Working through the Community Benefits Fund with local partners, making it an enforceable commitment, and creating a nexus between the fund and these land use and economic impacts could improve the project's posture relative to policy DPP2. For Sql impacts, the department has failed, for several Sql impacts, the department has failed to identify mitigation measures to reduce significant and unavoidable impacts resulting from land use conflicts when feasible. As an example, project noise from pile driving and other construction activities was discussed at length during the October hearing. And while implementation of mitigation measures proposed or adopted by the department could include maximizing the use of alternative, less impactful techniques, the extent to which those alternative techniques are feasible is to be determined through geotechnical evaluations to be completed at a later stage of design. Our recommended findings on this conclude that the department lacks the information necessary to demonstrate feasibility, that no remedy for noise in excess of established standards is provided by the proposed mitigation measure associated with pile driving in the event that alternative pile driving techniques are not feasible, and no performance standards or criteria for selecting alternative pile driving techniques are proposed. And for those reasons, and similar analysis supports our findings related to the other existing use impacts or conflicts identified here. And for these reasons, the department fails. Our recommended finding is that the department fails to demonstrate substantial evidence in the record to support its findings. Returning in summary then to policy GP1B1, this is the policy regarding overall consistency with the co-equal goals. This policy requires that a covered action be consistent with each Delta Plan policy it implicates. It recognizes that in some cases, full consistency with all policies may not be feasible. And in those cases, the project proponent may nevertheless determine that the covered action is consistent with the co-equal goals, but must identify areas where consistency is infeasible. The department's certification asserts infeasibility as an alternative approach to consistency for numerous policies, and as Mr. Stanbray indicated earlier at the October hearing, the department clarified its intent to invoke GP1B1 for policies DPP1 and WRP1. With regard to policy DPP1, which is the Council's policy to locate new urban development wisely, no appeal has asserted inconsistency with that policy, so our recommendation is the Council find it not applicable. And as stated previously by Mr. Stanbray for policy WRP1, the record does not support a finding of infeasibility for numerous reasons. So in conclusion, the staff's recommendation is that the department fails to demonstrate substantial evidence in the record to support its findings regarding policy GP1B1 for overall consistency. So in conclusion, staff's recommendation is that the Council find that the department fails to demonstrate consistency with aspects of policy GP1B3, policy WRP1, policy ERP1, policy DPP2, and policy GP1B1. And as a result, staff recommends that the Council remand the matter to the department for reconsideration pursuant to Water Code Section 85225.23. That concludes our staff presentation, and your staff team is happy and available to respond to questions during discussion.
Thank you, Jeff. Council members, any questions of staff at this time? All right. We need to take a 15-minute break sometime this morning. I think this is the most appropriate time to do it. We'll give the court reporter a rest before we begin hearing from the presenters, starting with the Department of Water Resources. So it is now approximately 10:13. We'll reconvene at 10:30. Thank you. Okay, welcome back. We are ready to reconvene. One correction that I want to offer in regards to the staff presentation on slide 15 of the PowerPoint, it was indicated the comment period would extend through noon on Monday, November 19th. The comment period will extend till 5 p.m. on Monday, the 19th. So just to clarify, you just gained 5 more hours for public comment. We will now begin with the presentations, hearing first from the Department of Water Resources, who has 15 minutes. Good morning.
Good morning. My name is Ken Bogdan, and I'm here representing Department of Water Resources. First, I'd like to acknowledge staff's effort in going through the mountain of information that was submitted, both for the record supporting DWR's certification of consistency, as well as the 9 appeals. It's a lot of work in a short amount of time, and appreciate that effort that staff went through. What we're going to focus on today is some information, hopefully to add clarity to the issues that the staff has raised related to the certification of consistency for DWR. I'm sorry, I don't have the control for the, thank you. And first, I'd like to touch on the foundational component, of course, of the council's review of the certification of consistency and whether DWR presented substantial evidence as part of our record to support the detailed findings related to the certification of consistency. As staff's determination points out, that includes enough relevant information and reasonable inferences so that a fair argument may be made to support DWR's conclusion, even though other conclusions may also be reached. This, of course, does not mean staff is reviewing specifically for errors or not submitting or substituting their own findings for that of DWR's. DWR is going to focus on the four major components that were outlined by staff previously related to where staff recommended granting the appeals and remanding related to DWR's certification of consistency, best available science as it relates to the climate change and sea level rise, the reduced reliance requirements associated with the water suppliers, as well as the GP1 component related to the feasibility of meeting those requirements and showing that WaterFix on the whole was consistent with the co-equal goals. We'll discuss the delta flow objectives, of course, related to the EI ratio, and also the M&I chloride standard that, that staff also focused on, and then discussing a DPP2 related to the local land use conflicts when citing water facilities. So first, and I should offer a couple things. One, we submitted yesterday a detailed writing, in writing, a detailed discussion of all of these components. It was circulated to the listserv last night. We had attempted to get it out as quickly as possible for today's hearing and wanted to do it certainly before Monday. So I'm not going to go into detail of each of those elements, but I certainly refer to you to look at that, those detailed discussions there. Also, when we are answering questions, or if you have questions, we have some of the experts that put together a lot of the record that DWR utilized to support our certification of consistency. We have them here, and I'm happy to have them come up and explain what's in the record supporting our decisions related to these issues. So when there are questions and answers, I might be calling on a few people to help discuss the record. So first, best available science, DWR, or I should say staff, said that DWR should have followed the NOAA and the OPC recommendations related to infrastructure design and projecting to the year 2100 for analyzing sea level rise. Staff appears to have mixed that standard, which relates to risk and policy recommendations for infrastructure design, with what should be best available science for modeling, hydrologic modeling, in preparing an impact analysis. Two different things. The NOAA OPC policy recommendation is not a scientific standard for modeling purposes, but instead, again, policy recommendations related to the design of long-term infrastructure. We should note that DWR and WaterFix design is consistent with NOAA and OPC's recommendations in designing WaterFix and the intakes associated with it and the infrastructure, incorporating a 200-year flood event, 55 inches at the Golden Gate. So in the design of WaterFix, which these standards, if you will, well, they're not standards, but these recommendations were mentioned, is one component. The other component, how does this fit into the hydrologic modeling to perform an impact analysis, which is a different question. And that question, our experts looked at the variety of input from a number of sources, including the NOAA OPC, to determine what was the appropriate method of analyzing impacts, not projecting so far in the future that the impacts would be wholly speculative, and going out, one could argue, to 2100 might do that, but instead looking within a range of estimates for analyzing the potential resource effects. So our experts, we believe we have information on the record, substantial evidence that our experts supported using the appropriate climate change assumptions related to the hydrologic modeling. Focusing on reduced reliance, the staff determination applied their interpretation of WRP1 to basically determine that it mandates that the urban and ag water management plans contain the information related to subsection C1A through C. Staff determined that absent compliance with those components, that DWR, WaterFix, could not then move to the issue of whether WaterFix and the lack of showing of this information significantly caused the project to be proposed. And then, separate from that, the staff had mentioned that, or had found that DWR would not be able to show that WaterFix, on the whole, was consistent with the co-equal goals. The whole reason for the Delta Reform Act, the acknowledgement in the Delta Reform Act that BDCP with this conveyance component was one could argue, critical to the meeting the co-equal goals. We couldn't demonstrate that because we had not demonstrated that it was infeasible to meet the reduced reliance component. So I'll go through those elements. As staff acknowledged that A1, A2, and A3 all act independently in whether the WaterFix was consistent. We'll, as a side note, acknowledge that although Appendix G is guidance, it is not a regulation that requires that we follow that. The certification includes substantial evidence showing that reduced reliance on the Delta for urban and ag water contractors was present. The requirement is not to follow explicitly what is delineated in C1A through C. The policy says must show it is consistent with. That's the words they use. They don't say you must explicitly follow. It says you must be consistent with these requirements. DWR created a record that shows we are consistent with the components related to this. We don't follow them explicitly. We aren't able to show that each of the urban water management plans and ag water management plans have a component that analyzes in specificity related to C1A through C, but instead create a record with what we feel is extensive information on how the water contractors and potential participants in WaterFix have addressed reduced reliance and also have discussed regional self-reliance. I just want to make sure I covered everything there. The other issue I wanted to make sure that we cover is that other component of A2, which staff had said because we can't show the reduced reliance component, we don't get to show that the need for the project was independent of the reduced reliance element. WaterFix and its predecessor BDCP preceded the Delta Reform Act. It came before it. The need was identified and has been supported extensively in the record related to the addressing climate change, addressing earthquake risk, and of course addressing water supply reliability related to the restrictions associated with the current regulatory environment, as well as the fish population decline. So we believe that we have shown in the record that the need is not based on a failure to show reduced reliance. I'm going to have to move on a little bit quicker here. Also, in terms of feasibility, if council follows staff's interpretation of WRP1, we feel that we have shown sufficiently in the record that DWR lacks the legal authority to require the specifics that are in A through C related to the urban and ag water management plans or require revisions at this time. And therefore, we believe that that showing allows for us to find that WaterFix is consistent with, on the whole, is consistent with the co-equal goals. Delta flow objectives, the two issues that staff focused on, the EI ratio and the Contra Costa Canal M&I chloride standard. The EI ratio cannot be modeled with WaterFix. EI ratio was put in place related to current Delta configuration that doesn't include WaterFix. If we were to follow staff's recommendation to attempt to model it, it would in fact change the EI ratio. DWR looked at the intent of D1641 in order to address how we were going to be able to do water quality modeling to assess impact analysis. We believe we created a more restrictive regulatory operations that address D1641's intent. In addition, the M&I standard, the project information shows that WaterFix doesn't create any impacts over and above the no action. So there actually isn't an impact associated with this issue. The modeling shows that there's a 5% exceedance in certain times, equivalent to the no project. And I will say that our historic evidence greatly supports the compliance with D1641 related to this issue. The TUCPs, there has never been a TUCP requested related to deviation of the M&I chloride standard. With respect to local land use issues, staff determined on a number of local land use issues that DWR was inconsistent with the policy. The staff reads into the policy a requirement to mitigate where feasible, where the policy states specifically that facilities must be sited to avoid or reduce conflicts with existing uses when feasible. It does not discuss adopting all mitigation where feasible. However, DWR has adopted mitigation, 50+ mitigation measures to address various land use conflicts. It appears that staff has independently reviewed each of those mitigation measures to determine how they feel they are not adequate to address those land use conflicts. So in sum, we request that the council direct staff to revise their determination to deny the appeals. We believe that there is substantial evidence on the record to support our determination that California WaterFix is consistent with the relevant Delta Plan policies. And I will note, of course, that WaterFix certainly furthers the co-equal goals and is, on the whole, consistent with the co-equal goals of the Delta Reform Act. Happy to answer questions.
Thank you for your presentation.
Thank you, Council, for being here. I want to ask 3 questions. 2 are probably best described as 30,000 feet questions, and then 1 is probably more in the weeds. I want to reference a statutory section that appeared in staff's presentation, but I haven't seen too much discussion on, and this is Public Resources Code 29773B. And this code provision, I read it to put a duty upon us, the council, and it says if the council, in its discretion, determines that a recommendation of the Delta Protection Commission is feasible and consistent with the objectives of the Delta Plan and the purposes of this division, the council shall adopt the recommendation. And I wanted to give you, council, a chance to tell us what you think that provision means.
When the Delta Stewardship Council was developing the Delta Plan, we believe that input, this section relates to that, to input in developing the Delta Plan. For appeals on the consistency with the Delta Plan, though, there are separate provisions that you have in your administrative code that do not separately provide for the Delta Protection Commission to sidestep the appeals process and direct the Stewardship Council to find one way or another.
So is that statutory provision not in effect any longer, or is it, you're saying?
I don't believe it's
doesn't
applicable to
cover
the hearings on appeals for consistency.
So even if they put out an official finding, they had a notice public hearing themselves, the commission, and they put out a specific finding that some other course of conduct was feasible. That has no effect on us right now.
I believe it helps inform your decision in reviewing our substantial evidence.
Got it, okay. The second question I want to ask is, this pertains to finding WRP1, and this, of course, is reduced reliance. From a big picture level, we heard some of the appellants say at the past meeting, the October hearings, that, and also this was something that public comment made, and I want to give you a chance to address this. They articulate this concept, and I hope I don't do it an injustice, which is, of course, the whole point of WaterFix is to increase reliance on the Delta. What do you say to that?
I would say that it doesn't increase reliance. So WaterFix was proposed to address some very serious components related to the ecological challenges within our current system. And there's a needed improvement to an outdated system. I don't think there's anybody that would disagree to it. So WaterFix is trying to address, looking forward, how to best accommodate the needs of existing water users who are all trying to address this reduced reliance and conservation and other issues. So with this component, it's to ensure that water becomes more reliable, but not necessarily more plentiful. There's not in fact, the modeling shows in certain years, WaterFix would not, I don't want to use the word produce, but there would be less diversions in certain water year types with WaterFix because of the projected additional restrictions that would occur in certain year types with our current and expected regulatory environment. So if you look at the no action with all these restrictions as tightening up further and further the ability to access water, and then look at it in comparison with what WaterFix does to add flexibility to the system, it's trying to address that issue, but not create or increase reliance on the delta.
Got it. Okay, now getting into the more specifics a little bit. So going to the staff findings, and this concept I wanted just for you to talk about for maybe 1 minute, 30 seconds, whatever. The department states that WaterFix was not significantly caused by a failure to adequately reduce reliance, but rather by factors that predate and exist independently of the reduced reliance policy. And the appellants, of course, dispute this conclusion, contending that Delta exports resulted in the environmental problems that DWR now maintains are causing the need for WaterFix. So we have a bit of a circularity issue with some of the things that the staff noted. And I just wondered, could you specifically, so I grasp the concept that some of the policies that we are now applying, both statutes and regulations, they arose later, they arose within the last, let's say 10 or 20 years. But I'd like you to address this conclusion that the exports have resulted in the environmental problems, because we have heard that from our scientists before. And so I'd like you to address that.
Well, certainly our existing facilities don't require a certification process. So you're assuming legislature understood we have this existing system and then tried to project, well, how do, looking forward, we create a process in order to address the ecological issues associated with the delta as well as water supply reliability, right? It's the co-equal goals. It wasn't saying get rid of that component, right? And they were explicit. So from this standpoint, when you look at the availability of water and from the State Water Project and the declining ability to, or I should say the increasing restrictions related to operations in the South Delta, it became apparent that DWR was going to need to figure out a way to try and address the declining population of the species in relation to the reliability, along with this increasing concern on sea level rise and salinity intrusion for the South Delta. And the estimates of the South Delta, where there are more challenges associated with this, led the engineers to determine that dual conveyance was an appropriate proposal to try and address that. So it wasn't in relation to increase in exports. Of course, we're not asking to increase exports. It was focused on trying to solve the existing decline of species issues that were to some extent, well, to a large extent, present in the South Delta where the existing facilities are, but also trying to do some long-range planning in terms of trying to address sea level rise and trying to address the concerns related to levee failure due to earthquake, which, again, when you add flexibility to the system, you're addressing that. That need has nothing to do with reduced reliance.
Got it. Thank you.
Frank?
What is your definition of the word consistent?
That you meet the spirit and intent of the policy.
Is that a dictionary definition, or is this your personal thought about what consistent means?
Well, I didn't, no.
Well, you said there's a big difference here, and I want to know, the word consistent means something to me, but I'd rather hear, what is the definition of that in common parlance in terms of the dictionary definition? Do you have one?
I don't have one in terms of a dictionary definition.
Would that be
To me,
helpful to
there's...
us? Would that be helpful to us?
Sure. We can supply that in an amended submittal before Monday at 5.
Your response is it meets the spirit.
Yes.
The way you view that.
Yes. Well, and if you also look at what the WRP1 talks about and the Delta Reform Act talks about in terms of a policy of the state to reduce reliance, and that individual water contractors are focused on self-reliance, regional self-reliance. It doesn't talk about it in terms of a specific accounting that has to be done one way or another. These are recommendations on how you could do it, but it's not the only way to do it, is my definition of consistent.
With respect to the best available science, wouldn't a longer-term horizon, such as the lifespan of a project, be the best way to determine best available science?
Best available science isn't always worst case. Best available science...
That's not the worst case. What is the lifespan of this project?
It's estimated 100 years.
Right now, wouldn't that be logical to look at that horizon to determine the best available science?
It would be logical where it's reasonably foreseeable to estimate impacts. And our experts said, when you go out that far, it's speculative to estimate impacts on how you factor in sea level rise.
So you would disagree with NOAA or the Corps or other available projections with respect to that estimate?
Well, so we actually, I'm
excuse me,
sorry.
would they be considered speculative in your mind?
So I wouldn't use the word speculative on NOAA's recommendation. NOAA's recommendation is basically a policy recommendation on designers of infrastructure on how much risk you can stomach in terms of designing a project. So from that standpoint, designers probably, for a long-term type of project, want to be risk adverse. And so they're going to design something with a bit more of a flavor of worst case, but that's design, which is different than impact analysis. And so from an impact analysis, we are focused on what is reasonably foreseeable in terms of estimating the potential effects of WaterFix from a hydrologic modeling perspective.
Wouldn't that the logic apply to the DWR you just described?
Yes, yes.
The worst possible case would be something that you would be interested in, I think.
So, and I'm sorry if I wasn't clear in my presentation, we have designed it consistent with the NOAA standard. We've designed WaterFix consistent with the NOAA standard. And I have our engineers here happy to discuss that further if you'd like.
When the DWR says, quoting your language, it will take months to review each water supplier's water management plan, quote, to determine if and under what circumstances they receive water from other suppliers up to a level of an SWP or CVP that will receive water supply reliability benefits of California WaterFix. Is this a matter of, in other words, I'm getting at here, are you saying that if we were given more time, we could get this information with respect to agriculture and urban water plans? Is that what you're saying? Given time, you could do that.
So I believe the way the staff determination is written, if we did that more time, we still wouldn't meet the standard that was set because we wouldn't have followed A through C explicitly.
Well, but you are saying with more time, we would do a better job. Is that what you're saying?
With more time, we could have compiled additional support on that next level of downstream water user on which molecules of water they receive from the delta. So we would have been able to get to that next level to compile a list of those entities. Now, I don't believe that would have met the standard that was set in the draft determination.
Whether it would or wouldn't, the question I have is, wouldn't that put you in a better position with respect to the certainty with which you could describe whether or not this would reduce the reliance on the delta if you had that information? Wouldn't you be in a better position to make that statement than you would be now?
I think that the amount of information that we have compiled in our record currently addresses those issues. It doesn't go to the X level of water entity deliver water on a local level, the suppliers of water. So that's what we were trying to address, is we expected in the questions that the intent of the question that we were responding to was, why didn't you give us that next level of information in terms of the list of potential water users. I believe the issue has turned slightly related to the standard that staff feels is necessary to meet this. And you give me 3 months, 5 months, 10 months, a year to compile that information that we listed, and I would argue that it still doesn't meet the staff determination standard.
Well, when the WRP1 refers to water suppliers that have done all the following are contributing to reduce reliance, and then it says completed a current urban and agricultural water management plan. Do you think that that means that you have to complete a water and management plan before you can proceed under WRP1?
No.
You don't think it does?
No.
I mean, it's something different.
Our record shows we're consistent with that. We've done the analysis, the water agencies, we've supplied substantial evidence to show the analysis that the water agencies did related to reduced reliance, the measures that they've taken to show regional self-reliance. And so we believe that we've produced a record that is consistent with that requirement, but would not equal.
That kind of turns on your definition of consistent.
Correct.
And it's the spirit, as opposed to anything more stringent that we would apply under a WRP1. Am I correct?
Yes.
Okay. When you say, quoting your language, it is difficult to ascertain with certainty which agricultural suppliers may receive benefits from WaterFix, that's the same thinking that you just expressed.
Exactly.
Certainty is not something you are required to do, and it doesn't necessarily affect WRP1 at all.
Correct.
Okay. With respect to delta flow objectives, can the compliance point for the required E1 ratio be different than what D1641 specifies?
We believe it has to be.
It has to be inconsistent.
It has to be different than the current D1641, because D1641 and the conditions that D1641 were promulgated to function in would not be the same with WaterFix, because it was a requirement for the EI ratio based on the CVP and SWP only drawing water from the South Delta. Once you add that new diversion point, you have to look at how EI is calculated and reconfigure it in order to address the new component of the facilities.
So under these circumstances, you wouldn't apply the word consistent, I take it?
I would say we're consistent with the intent of D1641, and the intent of D1641 is to address entrainment.
The staff indicates, with respect to the data that you show, with respect to I'll just read from the staff report, in 98.8% compliance rate, if DWR's own data shows that 60% of the days in 2009 water quality fell short 60% of at least one applicable standard, while under their metric it exceeds just 3.7% of the time. You're familiar with that reference?
I am familiar with that reference. We believe that staff got that wrong. So, and
how did they get it wrong?
I've asked Steph Morris, who's general counsel for the Design and Construction Authority, to come assist me in responding to that.
What I'd like to do is have staff respond to this answer while we're talking about it, okay? Go ahead.
So, in regard to D1641 and the chloride objectives, there is substantial evidence in the record directly on this, and it is cited in DWR's response. It is a chart showing the exceedance metrics and when they were and were not met, and that is marked as DWR 402 in the change petition proceeding. What staff referred to in terms of the chloride, they did not look at the actual data, which did not change with TUCPs. If you look at the record overall from 1995, when D1641 was in effect, there was 7,670 days that the 250 milligram liter standard had to be met, and there was only 13 exceedances, so 13 days out of the whole 7,670 day period. And those are actual, that's not modeled. In addition to that, in 2009, it appears what staff looked at is said they can't determine which standards weren't met. But if you look at this chart, it's one standard that wasn't met, and that was the in 2009. It's on the second page of DWR 402, and I'm summarizing evidence that's in the record to be clear here. There was only one standard that wasn't met, and that's the South Delta salinity at Old Middle River. And all of the, I'm sorry, not Old Middle River, at the ORT location. And all of those were one standard. Every other standard was met. And if you look at DWR's response, it explains that the reasons that salinity standard wasn't met are beyond DWR and the Bureau's control, and there's evidence in the record from the operators describing this, as well as it's been evidenced by the State Water Resources Control Board. So I would just summarize to say that it was one standard that was outside of the control of the department, and the evidence in the record did demonstrate that. And then the second point is on the Contra Costa chloride, that actually there's never been any variances in that standard, and it has been met all except for 13 days since 1995.
May I have a response from staff, please?
Yes, thank you for highlighting the locations and the evidence where that's pointed to. I actually would like to ask a clarification on that as well.
Speak in the microphone.
Yes, I'm sorry. The example that we gave for 2009 was one example. Staff's analysis, however, considered how we were to ascertain if the evidence supported compliance with D1641 and therefore ERP1. Overall, we are unable to ascertain, and our interpretation was that there could be other standards that were not met. So, for example, we don't know if it was reported as the actual number of days that any given standard was or was not met, or if there was a day with multiple standards that were not met. Your clarification helps with that, but I think there's two different issues. One is the Contra Costa, which we'll take another look at that. The other one is the overall compliance, and I'm not sure if you can clarify on that. Was that a single standard as well?
In 2009, it was a single standard, and if you want to look at the evidence showing the exact date, and it's not always one date, because as you know, D1641 standards are sometimes averages over a month or certain day periods, and if you look at Exhibit DWR 402, that's part of the record, you can see the whole compliance standard, and the testimony of John Lehi summarizes how that was done.
Thank you. Mr. Demerel, I guess I would like to also add that when we were looking at the table, it's a summary. It provides overall percentages of compliance for an elongated period of time for 1485 and D1641. We are not able to ascertain when we looked at it what the rate might be over different times. 2009 was highlighted, but for other years, for example, it was difficult for us to rely on the evidence and understand if D1641 was or was not complied with in any given period of time.
And I'd just like to respond, if possible, that the basis of the finding was that the chloride, that there's two chloride standards in D1641. There's a 250 milligram liter and 150. And the record shows that the 150 milligram, that's a mean average, has never been exceeded. It's only the 250, which was 13 days. And so if you look at the evidence in the record on that, it supports that there's substantial evidence that those standards have been met.
Okay. All right. Let me just move to a phrase that has not been defined, and I don't know what it's consistent with. I don't know what it means, and that's called the Community Benefit Fund. Is that kind of an afterthought, or did you think enough of that required a more fleshed out, precise discussion? And I don't find that discussion in your report.
So in our early consultation with staff from the Delta Stewardship Council, we discussed how we addressed land use issues that, from a CEQA standpoint, and as staff points out, from beyond a CEQA standpoint. The measures that we developed from a CEQA standpoint encompassed components of land use conflicts that went beyond CEQA in terms of outreach, developing plans not in isolation, but in coordination with the local communities, whether it be marinas for barge traffic issues, local transportation agencies, communities, landowners. So the approximately 50 measures that we outline in our certification of consistency go through various components related to addressing these land use conflicts. We also, within our CEQA discussion, included a series of what we called other measures that weren't to mitigate CEQA impacts, but were to address more broad delta concerns and conflicts that go beyond a physical effect on the environment. So we have, I'm getting a long roundabout way to get to the Community Benefits Fund, I'm sorry.
Yeah.
So as a part of that, the staff said it might be good to develop some kind of fund, and pointed to the Delta Protection Commission, and we said, okay, we'll try and incorporate something like that. In addition, we felt that without the Community Benefits Fund, we were consistent with the land use siting restriction, or where feasible, component of the Delta Plan policy. But we thought in order to further offset potential concerns within the Delta, that we'd offer a community benefits fund. So it wasn't an afterthought, it was something that had been discussed for several years. As I mentioned at the hearing last month, the idea was to try and develop that in coordination with the Delta Stewardship Council. We didn't have sufficient time to do that as we were moving through the development of the project. Has to do with timing. The large component of the design and construction of WaterFix has been coordinated with a new Joint Powers Authority, the Design and Construction Authority that Steph Morris is general counsel for. And so with the late development of that, it was difficult to add more definition beyond how we've proposed it. And in addition, we were limited on the amount of discussions we could have with the Stewardship Council as ex parte kicked in. So we offered this in addition to all the other elements that we feel address the land use conflict issues as something else that we feel will additionally minimize those issues.
Doesn't this get to the issue of time? I mean, if you had more time, you would have fleshed out what this really means and how much it's going to cost and who's going to benefit. I mean, isn't this a place to start as opposed to a place to just end up?
One of the challenges associated with a number of these processes, we have the Delta Reform Act that requires that we do certain things, get the change petition authorized from the State Water Board prior to construction. Those wouldn't have been a requirement. We could easily have started construction before finalizing the change petition process on land that DWR owned or whatever, possibly without completing the change petition process. But the Delta Reform Act added that requirement, added some other requirements, including completing the consistency process. So we were left with a challenge of timing in having a project that was defined enough, that went through the environmental review process sufficiently to, we feel, be able to certify consistency with the Delta Plan. There are components related to access to property that we weren't able to have because a lot of the property owners wouldn't give us access, and we had to work through all the way up to the Supreme Court to address that issue. That's why we don't have some of the technical studies that normally would have been completed. So there's a lot of timing issues that are a challenge with an environmental review process for a project this big. I would argue that we have the information that is sufficient to support our determination of consistency, and that, sure, if folks had more time, we would be able to have more information, but that doesn't mean we haven't met the standard. I believe we have met the standard.
All right, so with respect to the Community Benefit Fund, I mean, it's in the record, but there's no definition of it, there's no indication of how it even operates, or what it is. You've had a fair statement?
That's a fair statement.
Okay. Do you think that DWR had an obligation to spend more time on that subject matter, given the fact that you're looking at DPP2 as a very serious obstacle to this project? Wouldn't that make sense to really concentrate on that, so that the residents would know something about what might happen should there be the kinds of results that have been that the appellant certainly presented? Wouldn't that take some time and some effort on your part to do that?
Well, DWR appreciates that there are many land use conflict concerns in the Delta, and we've tried to address that from a number of different resource issues, looking at a resource issue, determining if there's construction conflict issues, use issues, and trying to develop measures to accommodate each one of those in relation to input from Delta communities. This additional measure we thought was an added way to minimize the effect, and we believe that the framework for it in presenting it consistent with, and we talk about good neighbor policies. I don't have the exact quote from our certification, but it has a few sentences to discuss the intent of the Community Benefits Fund, and in fact, in our submittal in October 15, we talk about the how we foresee this evolving. And we've already started discussions with the Delta Protection Commission, for instance, although not part of this record. So we feel like we are taking the necessary steps to develop additional information related to this, but we feel that the certification as it stands with the measures that we've proposed address DPP2.
One final thought with respect to the noise issue. And you alluded to this idea that you couldn't really get on the property to make the test, I guess, an alternate to pile driving. Is that what you're suggesting?
Correct. Yeah, you need to do geotechnical studies to see if that's feasible to do these.
So the pile driving in your mind seems like a pretty significant impact. Would you agree? The sound of pile driving.
Yeah. Mm-hmm. And we proposed
over years,
and we proposed mitigation. So the other thing that I believe that staff maybe didn't take the time to really focus on, or maybe they're independently determining that those mitigation measures aren't adequate. There's a number of mitigation measures to talk about the next steps related to determining where pile driving needs to occur from the low impact versus the higher.
Can you avoid pile driving?
Yes, in certain areas where geotechnically it'll.
It's part of the project, though, isn't it? Pile driving.
Yes. So, but pile driving of a certain type. So there's types that have less effect related to noise, right? And so this is the difference. There's certain pile driving techniques, and I'm happy to have the engineer come up to discuss this in a little more detail. There are certain pile driving techniques that have a much lower impact in terms of noise, but we need geotechnical analysis to support those. And we've set up measures to first do those next level geotechnical analyses to then discuss whether those are feasible. Okay. And we have other mitigation measures to address those that are affected. And so from that standpoint, we believe that it's not an all or nothing. It's not we're going to do pile driving and you're going to have to live with the noise, or possibly we can do the pile driving that has less effect. If it's found not to be feasible. There are several very detailed mitigation measures, if this, then this, that we have in place to further minimize the effects associated with pile driving.
Thank you. Thank you, Mr. Chair.
Yep, no questions. Just one last thought on the pile driving. The mitigation measures, would the Community Benefits Fund apply to some of those mitigation measures related to mitigating the sound?
So the Community Benefits Fund was envisioned as something over and above the mitigation that is necessary to address physical effects on the environment. It was over and above the replacement of conflicts with a specific land type or use. So the Community Benefits Fund would be is envisioned for addressing kind of broader conflict issues. We believe that the mitigation, though, associated with noise is funded separately. So this would be over and above that.
In terms of reduced reliance, you've stated that the information is available to do the calculations, to do the quantitative analysis, but you stated that you didn't feel that that would be adequate in terms of the way staff use this. Why not?
The calculations, so I may have misspoke. I believe there's another level of information that we could do to delineate the water suppliers at kind of the downstream level within each water agency and water contractor who and what supply of their water is connected to the delta. I believe what would be impossible for us to require is an actual amendment to each urban water management plan and agriculture water management plan to incorporate that analysis. So that's the part where I'm saying if the standard is must have it in an urban and ag water management plan, or must go amend those plans to include this with this detailed schedule, that's something that we don't think is feasible.
Okay, and you've stated in the record why you didn't, why the agency didn't pursue that as a requirement. So that's pretty clear. I understand Jeremy Brown has a question related to the reduced reliance. Step up to the microphone.
First question. Oh, pardon me. Thanks, Jessica. Jeremy Brown, Attorney General's Office, on behalf of the council. The first question relates to a discussion that appears on pages 55 to 56 of the draft determination. And if you
I don't have it with me.
And if you don't have an answer on the spot, that's fine, we understand, but we'd be grateful for any response you could give us prior to the deadline on Monday. And the question is, what are your thoughts on the amount or nature of consideration that the council should give to CVP water suppliers in a WRP1 analysis?
First, we will be happy to supplement our submittal that we distributed yesterday to elaborate on this. So the CVP, the CVP contractor involvement in WaterFix is something we discussed in our October 15 submittal, in that we weren't able to define the specific CVP contractors other than the Santa Clara Valley Water District who would likely be participating. But instead what we pointed to is the programs that Bureau of Reclamation has in place related to their CVP participation and addressing, in a broad sense, the regional self-reliance. So we believe we've created a record that allows for that reasonable inference that we've met the reduced reliance component, because right now it is not possible to pinpoint which of the CVP contractors are going to participate.
Okay. Thank you. Second question, you mentioned your submittal. Do you have a copy of that in front of you?
I don't,
Okay.
but Steph here does. Thank you.
Perfect. If you look at page 9, the first full paragraph, lines 8 to 10, there is a sentence that says, because of the way water is delivered in California, some suppliers have no idea how much of their water ultimately comes from the SWP or whether it will receive any water supply reliability benefits of WaterFix. And I believe that there are similar statements made in the October 15th submittal. In whatever supplement you provide to this submittal, we would appreciate if you could point toward any specific pages in the administrative record that would support that statement.
We'll do that, and I'll just give you a brief explanation now. Is Metropolitan, for example, is a wholesaler of water to a number of people and a number of sub-member agencies, and they have several different water supply sources. So State Water Project water, Colorado River water, and some, because of the way that the delivery systems are set up, some of their member agencies can only get SWP water, and some can only get Colorado River water, but a large percentage of them get some amount of blended water. And so it would be nearly impossible to say X came from SWP, because they also in their, and then this goes to that sort of layering, almost like an onion, where you have sub-member agencies have other additional water supplies like groundwater, and they rely on that as part of their portfolio as well. And so in some instances, it's almost impossible to say, I'm, sub-member agency of a Met member agency, and I am using X amount of SWP water, because there could be up to 4 or 5 layers of people who are ultimately getting water from Metropolitan, and it's trickling down through other wholesalers, through our member agencies, and then ultimately being delivered to houses.
Thank you for that explanation.
Real quick follow-up on that answer. Isn't it a little more precise than that? I mean, can't Metropolitan tell with, water like electrons is fungible, right? I mean, but the world of power trading, there will be very precise contracts where they will say, you drew this power from this plant at this time. And isn't that the same in the water world? Doesn't Metropolitan have very precise contracts where they say, well, your reliance this year, we sold you this many acre feet of Colorado River water, and because you couldn't draw this from groundwater, we're going to allow you to get this from this other source, from the State Water Project. And they have it down to the acre feet, I thought.
So the issue isn't can Met determine what their portfolio of water supplies are, it's where does that water go from there? And so there are a commingling of those water supplies. So yes, Met can, and that is in the record, tell you what portion of their water supply is State Water Project. The complication becomes as it moves down through their member agencies and then member agencies of their member agencies, they're not necessarily coordinating with DWR and complying with this reduced reliance in this very specific way that council staff has presented in the draft determination. And so that's really the issue, is can it be done sort of on a macro precisely? Yes, but as we move down into these sub-member agencies, that would require amending urban water management plans, which are on a schedule by law, and they only get updated every so often.
Okay, Skip, you have a question?
Thank you, Mr. Chair. One of the things that I've always wondered about, and your colleague mentioned salinity. How would you explain the effect on X2 with this project? Does it have an effect, I guess, is the first question.
So there's a number of X2 requirements. Are you talking about spring X2 or fall X2?
I'm talking from the layperson's point of view, the farmer on the river that is now starting to pump salinity instead of fresh water.
Okay, so X2 actually is really an outflow measurement, and your staff could probably explain this better than I can. But what you're talking about is ag salinity standards, which are required under D1641. And as the testimony is shown, and I think maybe John Lehi should come up, who is the operator who can explain this, is that the ag salinity, the standards are still met, and the modeling shows that the standards will continue to be met for D1641.
And I guess just if you think about it logically, if you move the intake from the South Delta up to the north, and you're going to draw up to 9,000 CFS, the flows are going to be reduced. And that, what I call the X2 line, is going to move into the Delta. How do you, without going into this PhD dissertation, explain to those of us in the audience how this is not going to affect water quality in the Delta?
So if we can have John Lehi, who's with the Department of Water Resources, add to that. And John, I don't know if you're a PhD, so.
No, I'm not a PhD. Again, John Lehi, DWR, Water Operations Manager. I'm not a PhD, but I do have well over 20 years of experience operating the State Water Project and the Delta being a big part of that operations. To get to your question, I think, is regarding water quality. The state board is the entity that sets those standards, and I think what our record is showing is that we would continue to meet the standards as we do today with WaterFix, and so there should be no change in the water quality generally as part of the project.
And again, because X2 is different than the water quality control standards, this project has higher spring outflows than are currently required under D1641. So if you're talking about outflows in different time periods, they are actually higher, and the X2 would likely be pushed out, especially in the spring. And the fall X2 requirements are under the biological opinions, and those are not changing with WaterFix, so they would be the same.
So what I was whispered in my ear is part of the question is evolving around times when the proposed project, the new North Delta diversion, would be diverting 9,000 CFS. Is that part of the question?
It's a diversion, it's 9,000.
Yeah.
It's a diversion that those that I've talked to are concerned about how it's going to affect their ag operations.
Yes.
As that line that I call it, it's being used further north into the Delta.
Right. So these higher export or diversion volumes rates would only occur when there was ample supply in the system. Excess flows in the system, so that wouldn't have an appreciable, shouldn't have an appreciable impact on folks downstream, because again, these are in conditions where we're flush with water. I mean, the project essentially is an opportunity to pick up these massive flows that we see during certain periods and certain year types that are above and beyond any requirements, where the water is already extremely fresh. That's the purpose of the project, is be able to take the opportunity to pick those flows up. Gives us flexibility.
I don't want to sparse words here, but you said would, and then you changed it to should. Is it would or should? Or are you just, we're going to wing it and figure it out later?
No, no, it's we have to comply with certain criteria, and that is always the case.
You said should, so there, to me, that leaves me to believe that you're not quite sure.
I'm sorry, could you repeat? When did I use the word should? Because I'm having a hard time.
About the flows, the salinity, you said, well, it wouldn't have an effect or shouldn't have an effect. Those were your words. I'm just wanting to know whether or not you're sure that it won't, or there's a chance that it might affect those salinity.
It won't have an effect that's significant enough to change compliance with requirements.
Okay.
Yeah.
All right.
Let me try and help. If and when you receive a change in the point of diversion permit, won't that clarify these matters? In terms of a concern about water quality?
The change in point of diversion permit would incorporate the initial operating criteria into the permit, which would set those standards at D1641, or as I mentioned earlier, for like Spring X2, higher than D1641, and for example, OMR, more restrictive than the existing biological opinions.
Staff, I have rather than wait until the end of the proceedings to ask for further information, this issue that has been brought up in regards to complying with WRP1 and the reduced reliance component that is lacking in the urban and ag water management plans, it has been suggested that because of that technical absence of that component in the ag and the urban water management plans, that they would be unable to satisfy you. The question, and I don't need an answer now, but eventually, would the equivalent of that information that is available and after analysis, would that satisfy the requirement of WRP1?
And I think I would ask Ryan and perhaps Jeremy to address that question.
I'm hesitant to without actually seeing what the particular information would be, and the particulars of that information, I think I would be hesitant to say one way or the other. That said, I think staff's current recommendation is that the information is required to be included in the plans themselves. That is the plain reading of WRP1 and a requirement of that. There was a discussion with regards to when and how such plans could be updated. They are on a 5-year schedule, ending in 5 and 0 years. However, I do believe statute does allow for those plans to be updated more often in terms of there is language that suggests at least every 5 years. So, and I think I would just also add that the requirements associated with the plans are separate from what's required in WRP1. The requirements in WRP1 apply specifically to projects, to covered actions that are occurring in the Delta, and the information, while similar, is not necessarily intended to be a one-for-one for the purposes of compliance with WRP1. I don't know if you...
I agree with all that. Mr. Chair, the draft determination does read subdivision C1 literally to require the inclusion of that information in the management plans. That is an interpretation that was reached in part by consulting Appendix G. It appears that the department and the council currently view Appendix G somewhat differently, and that's something that I assume will be discussed later today. I'm happy to address it now, but don't want to take us down too much of a tangent.
I'm satisfied to wait till later.
Okay.
Unless anyone else is... Okay. Any further questions of the project proponent? If not, then thank you. Thank you all very much.
Thank you.
Okay, we have time for one more presentation, I believe. Appellant Group Number 1, North Coast Rivers Alliance, has ceded their full 15 minutes. Next up will be Appellant Group Number 2, Save the California Delta Alliance, represented by Michael Brodsky, who has received 5 extra minutes, I believe, from North Coast Rivers. So you...
From the counties, actually.
From the...
North coast to the counties, and then it's a little market-based cap and trade.
Like I said, it would become evident once we got started. So you have 20 minutes. Please proceed.
Thank you, Mr. Chairman. Good morning, Mr. Chairman, members of the council and staff. Michael Brodsky on behalf of Save the California Delta Alliance. Let me say first that your staff has done a remarkable job on this report, even where I disagree with them. In the places where they overruled us, they brought up each and every one of the arguments we made, and they dealt with it. In the places where they overruled DWR, they brought up each and every one of the arguments that DWR made on that point, and they dealt with it. And that's better than most federal appellate opinions, which are worked on for months on end. So congratulations to your staff. I'd like to start by addressing a few of the things that were said by DWR previously. With regard to WRP1, this idea that it's infeasible for them to work with the water suppliers to include the required information for WRP1 in the water management plans is simply a post hoc litigation excuse. During the development of the Delta Plan, DWR submitted 10 comment letters. They commented thoroughly on the development of WRP1, and in their comment letter of June 20th, 2012, after an extensive discussion of the water management planning process and their engagement with the water suppliers in the water management planning process, they said, quote, DWR plans to work with its contractors and other water suppliers to meet the policy, end quote. And that is found, your staff has compiled the entire administrative record of the development of the Delta Plan. That quote is found on page K7492 of the administrative record. And I think a full reading of all of 10 DWR's comment letters and that comment letter will dispel any notion that there's any infeasibility. DWR just simply dropped the ball for whatever reason, whether there was institutional gap and people left, for whatever reason, they just didn't work with the water suppliers. In their, which I submitted into evidence through official notice, in their handbook that they used to advise all their water suppliers for the development of the 2015 water management plans, and through their extensive meetings and engagement with all of their water suppliers through the development of the 2015 water management plans. The Delta Stewardship Council is not mentioned once. The Delta Reform Act is not mentioned once, and WRP1 is not mentioned once. They just acted as if you didn't exist, and the Delta Plan didn't exist. And it would be really a travesty to countenance that by allowing them to get around the explicit requirements of WRP1. I'd also like to state for the record, and Mr. Brown will probably be delighted to hear this, Appendix G is not an underground regulation. First of all, it doesn't interpret a statute. It's a contemporaneous reading of your own regulation. Second, when you read Appendix G next to the text of WRP1, it's not that Appendix G is mandating something in addition, it's that Appendix G is persuasive that the lone legally tenable reading of WRP1 is that they must include that information in their water management plans. And so that falls outside the definition of any underground regulation. Okay, on the noise, Judge Damrell asked about that. So just to clarify, the current project that is before you has 23,900 piles that are driven by the impact method with 10,909,704 impact strikes at 115 decibels each. There is no possible mitigation for that. These are 48-inch diameter steel piles. They're 100 feet tall. They have to go down through the river and then be driven into the riverbed until they meet resistance. So that pile driving rig is sitting on a barge on the river. It's starting out 100 feet high, and it's hammering. The mitigation measures in the EIR are to do things like put shields around noise sources, like if you have a backhoe working or something. There's no possibility of any mitigation for that noise. The only possibility is to use drilled piers or CFA piles, which we have, and forgive the pun, we've been hammering on DWR to agree to that for 2 years now. We got a bid for them. They just insist that they're not going to agree to it until they do more geotechnical exploration. There are no access issues. This problem, the majority of these piles and the noise problems are on the foundation piles for the intakes, which are in the river. There's no reason why DWR can't go tomorrow to the Army Corps of Engineers and get a permit, or apply for the permit, and shortly thereafter get it, and put a barge out in the Sacramento River at those intake foundation locations and begin doing whatever geotechnical exploration they feel they need to do. So that's going to lead me to start my slideshow. If I could have that group A2. Oh, good, okay. All right, so with findings for remand, they can revise the project to address one or more of the council's findings. They can address one or more of the council's findings by providing more information, and they can file a revised certification of consistency incorporating the changes in new information. So one of the things they can do on remand is they can go put the barge out there, and they can get the information that they feel they need to have before they can tell us that they won't do the impact pile driving. So we believe that the department has not taken seriously the construction impacts. And we urge the department to take the many unaddressed significant long-term construction impacts to heart. Left unaddressed, the impacts from 11 or more years of construction would destroy the Delta as we know it. WaterFix construction impacts are not temporary. There are long-term impacts and are considered permanent. DWR has mischaracterized the construction impacts as temporary. They say, quote, regarding Captain Morgan's testimony on recreational boat navigation traffic, it is important to note that the significant and unavoidable effects are from construction and not operation and are thus temporary. Well, that's just wrong. Their use of temporary is directly contradicted by the project environmental impact report. Quote, construction of the alternative 4A intakes and related conveyance facilities would result in permanent and long-term, i.e. lasting over 2 years, impacts on well-established recreational opportunities and experiences in the study area. Here are some examples of permanent and long-term impacts from Table 15-15 of the FEIR. Wimpy's Marina, quote, up to 2.5 years long-term. Bullfrog Marina, up to 11 years long-term. Lazy M Marina, ongoing, up to 11 years long-term. The use of long-term and permanent is the EIR's use of it. Those aren't my words. That's their document. The FEIR emphasizes the adverse effects of the multi-year construction schedule. And one of the quotes below, recreation-dependent businesses, including marinas and recreational supply retailers, may not be able to economically weather the effects of multi-year construction activities and may be forced to close as a result. And that's a delta-wide impact. Here again is the delta-wide impact, a decline in visits, creating an adverse effect throughout the delta region. Here's just a recap of our Rio Vista where we surveyed boaters, and that slide's a little hard to read, but the majority of boaters surveyed said that they would either reduce their use of the delta or abandon the delta entirely because of WaterFix. And that was only 17% said they would not reduce their use of the delta in reaction to WaterFix construction impacts. We have uncontradicted expert testimony that at least 20% of delta marinas will go out of business, probably more. Those are sworn testimony from Bill Wells, the executive director of the Delta Chamber of Commerce, and Captain Frank Morgan. Captain Morgan says that he believes Mr. Wells' estimate of 20% is low. So this is why. This is an overview. All those dotted red lines there are barge routes, and all the features you see there are construction activities spread through the heart of the delta. Here is a description of the barges. This is from the biological opinion. They're going to be 200 to 250 feet long and 50 feet wide. The tugboats pushing them will be 65 to 100 feet long and 35 feet wide. That's a representation of what that kind of rig looks like. There are 18,800 one-way barge trips on Delta sloughs over 5.5 to 6 years. That's from the NMFS biological opinion. Here's a close-up. You can see the red dotted lines. The barges are just everywhere. They're going up the McCullummy River to reach the barge landing at the Meadows Slough. The McCullummy River is not trafficked by commercial vessels now. That's just a quiet, lazy slough. This is an overview of where the Meadows area is. We'll show you a close-up of that. So on the right, there's two photographs of the Meadows Slough. In that circled area there, you have a Meadows Slough staging area, barge dock, muck dumps, fuel station, concrete batch plant. That's a very pastoral and quiet and picturesque area. This is Hal Shell's Dawdling on the Delta, which is the classic work on Delta recreation and Delta culture. And Hal says, if popularity awards were given for Delta anchorages, the Meadows would win hands down. You feel a man could go in there and never be found. End quote. Captain Morgan comments, yet DWR chose this location as a major barge route, muck dump, and construction staging area, complete with concrete batch plant and fuel station, end quote. So here's another example of something that can be fixed on remand. That doesn't have to be at the Meadows Slough. I mean, that particular staging area doesn't have to be there. And in fact, DWR is considering moving it. So the project that's in front of you has that impact. On remand, they can go through their process, they can fix that problem, and when it comes back to you, that impact can be gone. Turning away from the Meadows, one of the most significant impacts that DWR missed entirely is the impact of increased road traffic on Highway 4, combined with opening the Highway 4 Old River Bridge 8 times per day to accommodate WaterFix barges. And the way that works is you can see down there at the very bottom, there's the CCF barge landing, Clifton Court 4 Bay barge landing. And then just upstream from that, there's the Highway 4 Old River Bridge. So the barges that go to CCF barge landing have to go under that Highway 4 Old River Bridge. That's the Highway 4 Old River Bridge. There isn't much clearance, height or width. There it is again. It's a low bridge. It's an old bridge. It was built in 1915. It doesn't operate very well. It sticks on hot days. So here we see 8 times a day one of these trying to go through there. It's going to be a disaster. And here's where we get the 8 times per day. This is from the NMFS biological opinion. The assumed number of one-way trips to CCF is 2185, and to Bolden Island is 3344. It is assumed there will be 4 trips to each of these barge landings per day and 4 returning trips back to the port of origin, for a total of 16 trips per day combined for both sites. So that's 8 trips per day to 4 there and 4 back. 8 times that bridge has to open every day. The EIR missed this entirely. Your staff deals with this somewhat in the report, but they say, the AR says additional raising of drawbridges in the study area would not be required. That's just false, and they provide no evidence for that statement. Here's from Captain Morgan, who's consulted the bridge heights and the routes of the barges, and the only bridge that the barge routes go under that will not have to be opened is the Antioch Bridge, and I give the citation there. Okay, the road traffic across that Highway 4 Old River Bridge will increase by 258% due to WaterFix construction trucks and worker traffic. And I've excerpted a portion of the EIR which shows those increases. The numbers are a little too small to see, but that's what it says, and that's at page 19-213. So here you have Discovery Bay. You have Discovery Bay Boulevard, which is the main access to Discovery Bay, population 13,500. You got the Discovery Bay Marina. The only way in and out of the marina is on Discovery Bay Boulevard off of Highway 4. And then you've got the Highway 4 Old River Bridge opening 8 times a day for WaterFix barges. So you've got a 258% increase in traffic on that road. And then you've got that bridge opening 8 times a day. It's going to have to stay open 20 to 30 minutes each time for the barge to clear. That's just going to create a traffic nightmare on Highway 4. It'll back up past Discovery Bay Boulevard. It will affect traffic, and it will also affect recreation because it'll be untenable to get to the marina. And here is to Captain Morgan's statement to the effect of what I just said, the sworn testimony. Okay, the pile driving, in addition to what we said before, the FEIR underestimates the noise level of the pile driving. The FEIR shows that it's going to be 60 dBA or less at Clarksburg, which is in Appendix 23A. Our expert, Charles Salter, states that the noise will be 75 to 79 dBA at locations in Clarksburg. It's important to understand that the decibel scale is logarithmic, so 75 dBA is more than twice as loud as 60 dBA. The FEIR correctly states that a 10 dB change in sound level is considered to be a doubling in loudness. DWRs has 2 primary errors. They're source and attenuation errors. They used the wrong source. They used 102 dBA for the source noise for pile driving, when actually it's 115 dBA. They used an attenuation rate of 8 dBA for doubling of distance, meaning if you're starting out with 100 at 50 feet, then at 100 feet it'll go down to 92 according to them. But the correct rate is 6. It would only go down to 94. Over short distances, that's not that big a deal, but over the significant distances we're dealing with, that's a very substantial, much more louder than what they say it is. They also make a fundamental error in their community annoyance factor, and they assume that communities in locales where the pile driving will take place are quiet rural communities. The large amount of intruding sound from pile driving will be less disruptive to community life. So they assume that where you have a quiet little town and you have a large increase in noise, that's less of an annoyance than if you were in a loud place like San Francisco when you introduce pile driving. And they've got that exactly backward. Common sense tells us that, and Mr. Salter's report here says clearly that they've made the wrong assumption that actually if you introduce impulsive, loud noise in a quiet place, there's a quote-unquote penalty of an additional 5 to 12 decibels. So the point of this here is their noise expert, and I was cross-examining him, and I say, do I understand that the intent of your testimony is not to dispute Mr. Salter's number of 115 dBA? The hearing officer interjects, but to emphasize the number that was used by DWR, and then DWR's witness, Bernarski, says, that's correct. That's the purpose of writing this section up. Hearing officer, all right. Mr. Brodsky, let's move on. Hearing officer, Mr. Brodsky, let's move on. Declare a victory and move on, Mr. Brodsky. So they have declined to dispute Mr. Salter's findings of all their errors. So the point of this, again, is on remand. Please take this seriously and do a serious noise analysis. In my view, because of what I've just said, there is no substantial evidence as to any noise level that DWR is presenting. It's not presented, it's not supported by facts as required for a substantial evidence showing. And that's the end of my presentation with 35 seconds left.
Very good, thank you. Any questions of Mr. Brodsky?
Mr. Brodsky, you indicated that several times that remand would result in a change in this plan, in the project plan. And can you quantify, you mentioned it, Meadows, you mentioned a couple of aspects of the project that would change. Do you have a list or a number of those prospects where remand might prove to be helpful?
I don't have a complete list offhand. I can say certainly the removal of that area at the Meadows. The other things, as far as the barges and all the barge routes that I showed you, just virtually every slough and backwater is beset by barges. We're moving into a phase now at the Water Board hearings where we'll be submitting our request for permit conditions. So one of our requests for conditions will be that the barges would operate only in the San Joaquin River Ship Channel, and that these massive muck dumps and other staging areas that are within Delta recreation areas would be moved out of the Delta recreation area to someplace like the Port of Stockton. Other things that obviously would be addressed would be the pile driving noise. The EI ratio could also be addressed. Mr. Lehigh was here earlier in terms of the EI ratio in our colloquy at the Water Board. The EI ratio is not just a technical thing. Currently there's a 35% cap, export to inflow ratio. If you remove that 35% cap, I took Mr. Lehigh through an example on a summer day where the flow was about 19,000 CFS, and showed him that they could divert 45% on that day, absent the EI ratio, and asked him to point to anything in the WaterFix operating conditions that would show me that I was wrong, and he could not. And that was at that occurred on I believe it was August 16th, 2018. I'll get the exact date and submit that with my comments on the certification. So that EI ratio could be addressed. Another thing that could be addressed is that, as your staff noted, because of that change in the EI ratio and because also of the way the operating rules are set up, they basically have free rein to export as much water as they want to in the summer. The summer bypass requirement is only 5,000 CFS. So in the other months, we have things like Ms. Morris was talking about, the X2 requirements, the fall X2, the spring outflow, et cetera, et cetera. Those are all requirements to benefit the fish. And so outside of the summer months, they have a lot of requirements, complicated formulas of what they can divert through the North Delta diversions. So on remand, they could address this issue with the EI ratio and put in place a more realistic operating criteria so that they wouldn't be draining so much water in the summer months. The original rationale for WaterFix for a new point of diversion was big gulp, little sip. When there are very large winter flows and storms and there's more water than anybody knows what to do with, we can take a big gulp. At all other times, we're going to just take minimum amounts of water. The way the project has evolved is exactly the opposite. Where they hope to get more water and where they hope to get their reliability for their water supply is by taking more water in the summer. So that whole thing could be addressed. So those are a number of things.
Well, are there some matters upon remand that could not be addressed because it's infeasible?
Well, there's the overall policy idea of many of us that the way to solve this problem is through a portfolio approach, through developing local and regional supplies, not through locking in the delta. And I think it was your question, or it was Commissioner Gatto's question, aren't you really just locking in the delta source of supply? So that would be a major thing to address, but it could be addressed if it was incorporated into a portfolio approach that was truly a big gulp, little sip project with the development of local and regional supplies that could be addressed. I mean, I think we've been doing this since 2006. It's 12 years now, and what, $500 or $600 million. I think if that effort had been, if half of that had been put in to developing local and regional supplies, as Mr. Obeji's testimony indicates that I've submitted into the record here, substantial pressure would have been taken off of the delta. But instead, it's really been a single solution focus on getting a point of diversion that gets our diversion point away from the smelt and gets our diversion point way upstream so that when sea level rise happens and salt water comes in, we'll be away from the salt water.
Any other questions of Mr. Brodsky? All right. Thank you very much
Thank you, Mr.
for
Chairman.
your presentation. We will now break for lunch. I show 12:07. I'm going to cut you short 7 minutes. We'll reconvene at 1 o'clock. Welcome back from lunch. We are reconvening and will proceed with appellate. If I could have everybody's attention. We are going to proceed hearing next from Appellant Group 3, Friends of the River, represented by Robert Wright. Good afternoon.
Good afternoon. Members of the council, Bob Wright, representing Friends of the River and Appellant Group 3. Chris Schutz, the water rights advocate for the California Sport Fishing Protection Alliance, is actually going to make our presentation to you this afternoon.
Bob, if I could interrupt you for just a second. Lita, we need to start the timer, please. Sorry for that. Tim, please proceed.
Good afternoon. Chris Schutz with the California Sport Fishing Protection Alliance on behalf of Appellant Group A3. Could we pull up our presentation, please? Thank you very much. Our presentation is organized into two parts: comments in support of staff's recommended findings, and key items on which we feel the council should make findings different from those recommended by staff. I'd like to first start out by agreeing with Mr. Brodsky in his commentary about the thoroughness and professionalism shown in developing the staff determination. I work in many different venues with many different regulatory agencies. This is almost unique in my experience in terms of how thorough and detailed and how far into the record a staff has gone in preparing a document, and we appreciate it very much, even though we don't agree with all the findings. So to start, we agree with staff on the EI ratio. On its face, as staff points out, the DWR has proposed a different project and one that does not comport with D1641. almost anticipating some pushback, they did a sensitivity analysis that would show compliance with the existing requirement. And they mentioned this at the previous meeting on October 15th. It's really not appropriate to sort of say, well, we think you should do this, but if you don't, just go ahead and do this and let's have a do-over right away, rather than remanding something that isn't consistent. And it seems to us that this is an effort by DWR to basically game the outcome in a way that they wanted to, and staff found that it was inappropriate. The right thing to do here is to have DWR go back, and if there's technical difficulties complying or showing how they would meet the existing requirements, DWR has the opportunity to present those in a full and straightforward way. We also support the staff determination on historic operations. And I thought staff did a very good job on pages 74 and 75 of the staff determination, deconstructing the way DWR has marketed its historical rate of compliance. One of the things that is cited there is John Lehi's testimony in part 1 of WaterFix. A line that he doesn't cite is that some of the standards govern operations much more frequently than others. And so by mixing in all the different points of compliance and adding them all up and saying, well, gee, we're complying at all these different points, but on this one or this one, we're not complying, and so our compliance rate is very high, it ignores the fact that there are specific points that are the pinch points, that are the ones that are governing. And when you're evaluating compliance, you really need to look at how the project overall is complying with certain key elements. There was some discussion earlier about the 2009 exceedances. To me, that's more valuable as an example than as a specific issue that substantively this council needs to deal with. It's just how you evaluate compliance. That's an extreme example, perhaps. But even if in that case DWR did not have control, the way that they're trying to argue the amount of time that they do have control is overstates the frequency with which they're able to comply with D1641s. I also frankly didn't follow the discussion this morning about compliance with variances, under variances. They clearly should not be allowed. If you ask for a variance to D1641 and then you're complying with the variance that you've asked for, that really isn't complying with D1641. So I think some further evaluation of that would probably be in order. Briefly, we support the findings on sea level rise. That's not our issue, but we thought it was important. On reducing reliance in the Delta, we're among those who've maintained for a long time that the project really is, as someone asked about earlier, designed to, in a way that increases reliance on the Delta. Going into the details of the staff's finding, it was very well enumerated. It's not limited to a new or expanded water right, and trying to invoke some legal theory about why it's not applicable just really doesn't comport with what we understand the Delta Reform Act to say on its face. The policy should apply to CVP contractors. The DWR has really tried to exclude that entire class of contractors. It's not just the details of what they do. But first they argued, well, they don't count because they're federal and there's nothing we can do about them. And then they said it would be hard to get the information. Well, part of the reason that it's hard is because we don't know which contractors are actually going to be involved. And that leads us back to the issue of, is this something that we should wait until at least the State Water Board issues a permit for before we decide what information DWR has to go out and gather. Otherwise, I think it is appropriate that DWR go and provide the necessary information for all those who potentially would be recipients of water under this proposed action. We think all three of the factors under subdivision A apply. There are significant adverse impacts. And as far as we know, we're not reducing demand, and we don't have records that show that water recipients have reduced reliance. So we believe that staff really got it right on this. And the appropriate thing is to remand this and get the information that you all need. Briefly, we support the various findings on land use. Those, again, are not our issues. But we want to acknowledge the work that staff did. And many of our colleagues today will be providing the kinds of details on this that are appropriate. We disagree with the finding, or the recommended finding by staff, that the adaptive management plans are supported by substantial evidence. So there are two basic kinds of adaptive management plans that we're talking about. One is the those focusing on Endangered Species Act listed species. But the Delta Plan under Water Code 85308 requires a formal adaptive management strategy for ongoing ecosystem restoration and water management decisions. This is not limited to listed species. And as far as we can tell, the project-wide adaptive management plan just contains an outline of what adaptive management would look like for the non-listed species and the other aspects that would be covered under the Water Code, the Delta Plan. This is what we've found in the project-wide adaptive management plan that was submitted to you all as part of DWR's filing on consistency. And there's a description of DWR's responsibility and how they're going to do some things, but we really don't see a developed plan. It's nothing on the level of what DWR developed for the endangered species. And we think that there needs to be, leaving aside our disagreements with the issues related to the adaptive management on endangered species, there's nowhere near the level of detail, and we think that's required and appropriate in order for you to find consistency. Regarding delta flow objectives, we disagree with staff's recommendation that you do not take official notice of the various federal documents that FOR and others submitted. These are shown in Exhibit C of the draft staff determination. These documents are extraordinarily important and relevant in light of the recent federal assertions that state law may not or does not apply. And the idea that any change in the relationship between reclamation and the department can be dealt with at a later time, we don't really understand how that works in terms of your procedure. There's a suggestion by staff that the changes could be made, or a new sort of project could be brought to you because of any changes, but between the relationship between reclamation and DWR. But is that really a new project, or is that simply a revision of the old project? And do you really have authority, once you approve and find consistency, to go back and revisit that And what is the public process for that? And what are the opportunities for legal review? We don't understand how that would play out, and we think it's important that that be defined, but more importantly, and better, we simply think that the right way to do this is not following the business model of approve now and revise later, but rather wait to approve until you've got something that's clear and defined where you're not going to have to make revisions in the future. We continue to maintain that the State Water Board should act on the petition for change. That's before there's really sufficient project definition to allow you to determine whether or not there's consistency. Not just, there were a number of other issues, and people have raised those regarding completion of the NEPA and CEQA processes and the importance of doing that before you find consistency. And we agree with those, but allowing the Water Board to act certainly would rise to the top, in our view, of something that really needs to happen before we really know what the project is going to be. In closing, the summary that we're presenting today is necessarily abbreviated and incomplete, and we'd like to thank the council for the opportunity to highlight our areas of support and concern.
That completes your presentation?
It does.
Thank you very much. Council members, any questions?
I have one question.
Yes.
Similar to the question I asked Mr. Brodsky. If the council decides to remand this matter, what do you hope to accomplish in terms of the project development or changes that DWR could address if it is remanded? I know it's a general question, but the general answer would be satisfactory to me.
First of all, I think that it's clear and it's fairly well known that we don't approve or agree with the project. But assuming in order to answer your question, that ultimately it will be approved, clarity on how the project will be operated, clarity on the role of the Bureau of Reclamation. I think those two are some of the biggest issues that we've raised and consistently had concerns about. Let's see if there's others. I think also the questions having to do with whether people are reducing reliance on the Delta are things that we really don't have information about in many cases. It's spotty, it's sporadic. I don't think that the sense that, I don't know where you draw the line between the intent of the law and just sort of approximating something, but just saying that, well, we've tried to get as much information as we could, but not having that in any kind of detail, and that's kind of, as I understand it, an acceptable compliance with the intent of the law. I don't think that's really right. And so I think more detail on some of the issues that we and other folks have raised today. There's a whole rash of issues that Mr. Brodsky stated that I think could be addressed, and he stated them much better than I can. That's really not our set of issues. Those are ones that come to mind right off the top of my head.
Thank you.
Okay, thank you both very much.
Thank you.
Next up, North Delta Cares Action Committee, Appellant Group 4, Barbara Daly.
Good afternoon. My name is Barbara Daly. I am with North Delta Cares, and I have with me Deidre Desjardins, and I will let her introduce herself, and she will begin our comments this afternoon, and then I will finish them up. North
My-
Delta Cares Action Committee. Thank you.
My name is Deirdre Desjardins, and I'm the principal with California Water Research. Can you put up North Delta Cares' first PowerPoint, please, while I... no, that's not it. That's the individual one, North Delta Cares. A41. There it is. California Water Research has been working with a team to analyze WaterFix construction impacts, and with North Delta Cares. North Delta Cares raised issues that the project mitigation was inadequate, including all of these issues. The staff, we support the staff findings. They said the department has not cited evidence in the record demonstrating mitigation members or alternatives which would reduce or avoid impacts are infeasible. We don't feel that a community benefits fund would address all the issues. One is construction noise. It's potentially 24/7. The commitment in the draft EIR-EIS to follow local noise ordinances has been deleted. It's very severe for Hood, and it could interfere with teaching in Clarksburg schools. This is the calculated noise in contours, as Mr. Brodsky testified. These are inadequate, but just they show the level of noise that can be expected in Hood and Clarksburg. Fraser Schilling testified for land that nighttime levels would be above 50 dBA, which is above thresholds found to disturb human health. He also said, despite the literature on negative health outcomes, the final EIR-EIS only considers noise annoyance. For air quality, there's huge work areas next to Hood and across the river from Clarksburg. And fugitive dust emissions calculated in the air quality analysis don't include wind erosion. So wind picking up dust from these areas is not included. This is Hood. There's an enormous workstation area. DWR is turning what looks like their entire parcel next to Hood into a work area. This is really, it's larger than the town. This is from the 2015 conceptual engineering report. On the left, it shows the work area. And again, you can see Clarksburg down at the bottom, and it's enormous. There's not just a noise issue, it's also dust, and there's issues that there could be hazardous materials in the dust. Sensitive receptor maps do not include Clarksburg schools or the community park at Hood. And their own tests of reusable tunnel material show chromium-6 in the tunnel mucks, potentially hazardous. This is the diagram of sensitive receptors, a close-up. It doesn't show any of the schools at Clarksburg or the community park at Hood. The reusable tunnel material testing report said that if it's to be placed in the environment by people could contact it either directly or as an airborne particulate, then a human health risk assessment needed to be developed. None has been done. Gas wells. The internal DHCCP engineering review recommended that the tunnel alignment avoid any active or idle gas wells and minimize intersection with plugged wells. This is a diagram of all the gas wells in the Delta. There's very large numbers, and these are what are known from Doger records. The outside review panel recommended, given that well coordinates aren't necessarily accurate, that DWR conduct a survey to determine their exact location. This has not been done, and they recommended they avoid all wells to the extent practical and avoid tunneling over wells, and that they would need to address each well specifically. This is a close-up of the active and plugged areas, plugged wells in the area. It's a significant issue. There's a significant number of wells along the tunnel alignment near these legacy towns. The proposed mitigation in the 2015 conceptual engineering report only indicates that the state of California may classify the tunnels as potentially gassy. This is not mitigation. And proposing to identify the minimal allowable distance in the future is not mitigation either. Haul routes go right past Cortland Lock and Walnut Grove on Highway 160 and have 24/7 traffic. This is a picture of the haul routes. Reza Mogizi testified that there would be dramatic and unprecedented increases in traffic levels. She was First County of Sacramento. And this is a picture from the conceptual engineering report. There's tunnel reaches, and they're proposing to excavate reaches 4, 5, 6, and 7, all of the main tunnel reaches simultaneously, which greatly exacerbates traffic problems. And I'll turn it over to Barbara.
Okay, thanks, Deidre. First of all, I'd like to thank you all and your staff for your hard work and all of your efforts on this appeal process. We in North Delta Cares Action Committee do disagree with the staff's findings on the impacts on the visual and aesthetics character of the Delta. And my comments are going to focus on the North Delta, this time from Rio Vista North, where the 3 proposed intakes are planned to be constructed. And we'd like to reinforce our comments on the visual and the aesthetic effects. So I'm only going to go into the traffic haul routes that Deidre just brought up in the North Delta. They follow much of the historical route of the Sacramento River. State Route 160 will greatly adversely affect the visual and aesthetic qualities of that area. There is no mitigation that I can think of other than to move the project to somewhere else or change the project. I don't know if it's infeasible to be addressed on remand or not, but I would leave that up to you. I'm going to show you some pictures of buildings and structures, if we could bring those up, please, that will experience direct negative effects, impacts, whether it's extreme noise, vibrations, visual disturbances, or road crowding access because of heavy truck traffic on the haul routes per the map, which I will show you, figure 23A-09. So if you would bring that up, please, DSC.3. And we do request that you support your staff's recommendation to remand the WaterFix back to the Department of Water Resources. This is the map. It's a little hard to see, but this is the route that the trucks will take. And I made a key that the trucks are going to go 24 hours a day, 7 days a week for the 13-year construction period, back-to-back hauling construction materials on Delta roads, which will devastate the Delta history and the historical communities. And the keys are State Route 160, which also River Road, Hood Franklin Road, Lambert Road, Sutter Slough Bridge, Walnut Grove Thornton Road, and Twin Cities Road. So I have these key 1, 2, 3, 4, 5, 6 throughout these pictures, and I'm going to go through them pretty fast, but you can see how narrow the river is up here. So on the right is 160, the route of the trucks, and that's the east side where they would be putting in the water intake facilities. The left side is where Clarksburg is. This is Freeport Bridge, came out a little dark. Built in 1929, it is on the State Historic Bridges Register. And it's very hard to see. Can you lighten that at all? Just go forward, okay. We have State Route 160. This is a Scribner Bend Winery. This is right on the road, right on State Route 160, where the trucks will be going by to a minute. State Route 160, this is a home right next to the shoulder of the road. You can see the lines in the road there. Rosebud Ranch was built in 1850. There we go. There's Rosebud Ranch, built in 1850. It's right next to the road, right next to State Route 160, where the trucks will be going by. This is on the other side of the road, but as you could see, the river's fairly narrow. There's a winery there. We have the old sugar mill where there's 15 wineries. That's right on the river road. On the other side, we have the Dinky Diner in Clarksburg, so close to where the batch plants of the cement will be, right across the river. And I'm going to go through here. You can see Clarksburg was established in 1850. It's over 100 years old. This is the community church, just a block from the river road, just a block from the water. And there, the community church, you can see, is very well attended. Right at the top of the trees is where the road is. And this is the Clarksburg Library, very well attended. The children go there, the grade school children go there once a week, every week, to get their books. The high school is within a block and a half from the river road where all the trucks will be going back and forth, as well as the middle school, as well as the elementary school are right there. This is, you can see the line in the road, that's the river road where the trucks are, and the batch plants are right on the other side of the river. It's so close to the construction. This is Hood. This is right on at Hood Franklin Road. And this is Hood Franklin Road and State Route 160 where they intersect. There's a restaurant there. Hood Community Park is right on Hood Franklin Road where all the trucks are going by to a minute. Right, going back up to State Route 160 and on the water, we have another older home. We have the Hemley Pear Farm, that old, beautiful, historic home there. The Elliott's family home. This is the Cortland Docks, right there on the water. And another family home. This is the Sutter Slough Bridge. You'll see here the trucks will be going over this bridge. It is on the State Historic Register. This is the Paintersville Bridge, also on the State Historic Register. This is the Walnut Grove Bridge, also on the State Historic Register. This is the family farm of Tim Newharth, and the sign up there, you can't see it, but it says it was established in 1848. And he has just put in a new restaurant there, right on the road where the trucks will be going by at Sutter Slough. You can see how narrow the roads are, with Pearfields on the left and the Sacramento River's on the right. The traffic jams are going to be pretty difficult. This is the Sutter Slough Bridge. We have the Grand Island Mansion that was established in 1917. Many wedding events out there, Sunday brunches, more homes. Walnut Grove. This is where that boat is. That is a public dock. Those buildings behind it are the route that the trucks will be on. That's the main street right along the route. We have Deckhands Marine on the other side. The environmental review said that building will be gone. As you can see, Walnut Grove was established by Chinese and Japanese, two different districts, and this is what it looks like today. These are very recent pictures. This is the Imperial Theater. It's on the National Historic Register, established in 1920. And a park, a community park, just a block from where all of the trucks will be going back and forth. Behind it is a school, the Tong Building. Another building, many of the shops will show that they were built in the 1870s. This is a park. In fact, it is the gateway to the Delta Meadows, which isn't very well kept by the state. People are not even allowed to walk down there or drive down there right now. Now we're in Locke. As you can see, Locke is right here. It's very hard to see. The shadows didn't look like that when I put it there, but there's a road right there. It's right on the highway. Right at the top of that little incline is State Route 160. As you can see, it comes down. There's a museum there. That's a Chinese museum, children's elementary school. And this is downtown Locke. And Locke, the EIS says that the historic buildings will fall. They will be very severely damaged. And another building in Locke, just to show you some of the Locke buildings. This is a memorial park in Locke to the Chinese who built the Transcontinental Railroad and who began to build the Delta levees, which are fashioned after the levees in the Pearl River Valley of Canton, China. So it is also affected by Twin Cities Road. That's what the 6 means. And one is State Route 160. This is the oldest building in Locke. It is Locke Garden, a Chinese restaurant directly on 160. And we have the Isleton Bridge. This is a 1-lane bridge for trucks and buses. It's not a 2-way when you have large vehicles. This is a sign that shows it was established in 1874, and State Route 160 goes across and through Ileton. We have the Rio Vista Bridge, and Highway 12 connects 80 with 5, and I'm almost done. I might have maybe 3 more. Passes Bolden Island. The traffic jams are already unbearable by the public. Mount Diablo, the Delta's compass, and our water code, which people have been reciting to you. The co-equal goals shall be achieved in a manner that protects and enhances the unique cultural, recreational, natural resource, and agricultural values of the Delta as an evolving place. To the Delta Stewardship Council, thank you for your hard work and for protecting and being good stewards of the Delta. From North Delta Cares Action Committee.
Does that complete your presentation?
Yes, that completes my presentation.
Any questions?
Yes, the same question. Are there feasible changes that you can, that should be made if this matter is remanded to the DWR?
Well, that's interesting because I know one of the things that's out in the public right now is that we're hearing that maybe 1 tunnel wouldn't be as devastating to the Delta as 2. And from the people who live there, we feel that the construction of 1 tunnel would be just as devastating as 2 tunnels. I don't know what you could do as far as the trucks, maybe a different route, I don't know. But the routes that have been selected are just not workable for us. It's just in the wrong place, and it's the wrong plan, in our opinion.
I just wanted to add that the siting at Hood is just terrible for these small legacy towns. And you can see the noise impacts, and there aren't plans for sound walls. There aren't plans to locate work areas further away from schools and parks. There isn't an adequate air quality analysis. And there's no justification for the aggressive schedule of boring all 4 reaches of the main tunnels at once. That, you know, it's like this almost wartime schedule that's just going to impact every part of the Delta.
Okay, thank you very much. Next up, the City of Stockton and the Sacramento Regional County Sanitation District, represented by Kelly Tabor, for a combined 30 minutes. Welcome.
Good afternoon, Kelly Tabor on behalf of City of Stockton and Regional Sanitation District. Chair Fiorini, members of the council, staff, thank you for the opportunity to comment on the draft determination. Stockton and Regional San support the overall recommendation that you find that the WaterFix project is not consistent with the Delta Plan, but we do believe that the determination doesn't go far enough in recognizing impacts to Stockton and Regional San. And so we're hoping today that our presentation will encourage staff to go back and take a second look and a really hard look at some of these issues, and I'll try to quickly summarize them. I have 2 presentations. I'll go through Stockton's first, and then we'll switch the PowerPoint for Regional San. And we will submit written comments by the Monday deadline that provides all of the detailed evidentiary citations that support the statements that I'll be making today. The draft staff determination for Stockton's issues relies on the WaterFix final EIR and a report from the Water Rights Change Proceeding, DWR 652, to find that DWR analyzed the implications of the project with respect to the potential impacts to Stockton's water quality, and that DWR substantiated its model choices and calculations. And Stockton maintains that when the evidence in the record is viewed in light of the entire record, not just DWR's report and the final EIR, that the evidence that DWR is relying on, both in terms of its modeling and its impact conclusions that are drawn from that modeling, does not meet the Delta Plan requirement for best available science on the criteria of relevance, inclusiveness, objectivity, and transparency. And the consequences of the failure to use and demonstrate the use of best available science is that impacts to Stockton's water supply reliability have not been recognized or mitigated. You've heard a lot of talk about the standard of review. We just want to emphasize the requirement is recognized in your staff's determination that evidence has to be of solid value. And again, you're looking at evidence in light of the whole record. And remand is required where a reasonable person could not have reached the agency's conclusion. And if you look at the entire record of evidence before you, I think you'll agree, and your staff will agree, that a reasonable person could not have found that this project will not make Stockton's water supply less reliable. The approved project, CWF H3+, increases the amount of time that Stockton cannot use its intake and have access to its drinking water supply from the San Joaquin River by 48% compared to DWR's no action alternative. That was documented in Stockton's evidence, Stockton 61 in the water rights hearing, pages 3 to 4. This translates into up to 2 months per year that Stockton's unable to use its water supply depending on the water year type compared to that no action alternative. DWR has failed to demonstrate the use of best available science. Its best available science is defined as the best scientific information and data for informing management and policy decisions. The factors I mentioned: relevance, inclusiveness, objectivity, transparency. Inclusiveness, as it's recognized in the determination by your staff, requires that scientific information incorporate a thorough review of relevant information. So we'll walk through that right now. DWR's impact assessment and determination for Stockton wasn't based on the approved project, CWF H3+, which has the most severe water quality impacts. The modeling that they relied on uses inaccurate assumptions about sea level rise. This is something that your staff has recognized. And that failure infects the value, evidentiary value of all of the modeling analysis for water quality, water levels. You can't find that the essential assumptions in the modeling are invalid and that the impact determinations that are drawn based on that modeling are valid. Your staff's already determined that that has to go back to them. And they also assumed D1641 compliance in their impact determinations. Your staff again found that that was not reasonable, that there's no evidence to support that because they are not relying on the current standard. The impact analyses aren't based on relevant evidence for water quality due to the way that DWR averaged the results of its modeling. By developing a mean monthly average for salinity, which is a big concern for Stockton and agricultural purveyors and others, it effectively averaged 15-minute data into daily data, then it averaged the daily data into monthly data, then it averaged the monthly data into mean monthly data, which was averaged over the 16-year model period. And the result of all of this averaging is that the actual change in salinity from the California WaterFix scenarios was masked, and in particular the daily changes in salinity that dictate whether Stockton and other Delta water suppliers can access their water were hidden. And DWR certified to you that its methodology was subject to review and comment, but that certification failed to recognize and acknowledge that experts who commented on the EIR and testified in the Water Board hearing universally condemned the approach that DWR took as misleading and inadequate for informed decision-making and irrelevant to drinking water purveyors who have to assess and respond to water quality changes on a daily basis or even more frequently. And this issue was not just Stockton's issue. The experts in the water rights proceeding and in the EIR commenting on behalf of all of the Delta entities, Antioch, Brentwood, Contra Costa County, Solano County, North Delta Water Agency, universally, those experts said this is not good enough. It doesn't tell all of the story and it doesn't tell the relevant story. So the impact analysis DWR had a choice in the methodology it would use to assess impacts, and it chose the method that obscured relevant information regarding potential impacts. And you heard Dr. Mel Lytle here last month tell you, and our evidence in the record shows that Stockton's ability to use its water supply is dictated by daily chloride levels. And so the lack of evidence in DWR's certification on the changes in the time scale in chloride levels that are relevant to Delta water purveyors, including Stockton, doesn't answer the question of what the effect will be on water supply reliability for Delta water purveyors. You have the criteria of relevance and inclusiveness. DWR's opinion that these daily changes in water quality would not matter to Stockton was based on flawed assumptions and irrelevant information. DWR submitted a response to you on October 23rd that cited testimony of a witness that it produced in the water rights proceeding, Doug Owen, as evidence that short-term increases in chloride wouldn't pose any impact to Stockton. But his testimony was not best available science, and it wasn't relevant because Mr. Owen had no experience with the specific type of treatment plant that Stockton operates, which is known as a T5 plant, and his opinion wasn't based on any relevant information about how it actually operates. And this came out in cross-examination. We'll provide you with all the citations to his testimony. Other Delta water purveyors can manage higher chloride levels because they divert to reservoirs, but Stockton doesn't divert to reservoirs. It diverts directly to its treatment system and straight to its customers. So in less than 24 hours from the time water is diverted, its customers use it in their homes and in their businesses. And so daily changes are noticeable, and they are can't be managed at a certain level, above a certain level, by the treatment plant. And had Mr. Owen consulted with Stockton before he formed his opinion about the impacts, he would have known that Stockton's system is different from other plants that he might be familiar with, and different even than some other Delta water purveyors. But Mr. Owen never spoke to anyone at Stockton about how its treatment plant was designed or operates, and the only source of information that he relied on in forming his opinion was watching a YouTube video that he found online that the city had posted to inform its citizens about its water rate changes. Recalling the best available science criteria of inclusiveness requires that scientific information incorporates a thorough review of relevant information. DWR did not conduct a thorough review of relevant information in assessing the impacts to Stockton, and it hasn't demonstrated the use of best available science. You also have criteria of transparency and objectivity. Notwithstanding his written testimony and conclusions in the EIR for the WaterFix that couched impacts to water quality in terms of whether the WaterFix would result in long-term substantial degradation of water quality, the author of DWR's water quality impact analyses, and the ones cited by DWR and cited in your draft determination, that Mike Bryan admitted upon cross-examination that a short-term substantial increase in a water quality constituent could result in an adverse impact, even if it didn't exceed a water quality standard, and that he would consider any increase that rendered source water unusable for municipal purposes to be an adverse impact. None of this was recognized in the EIR or the water quality reports that the department produced. And I've already commented on the amount of time that Stockton cannot use its intake, 48% increase compared to the no action alternative, as demonstrated by modeling when you disaggregate the daily data from these long-term monthly averages that I described. Relevant, best available science relevance. The determination does seem to rely on DWR statements that it can avoid impacts through what DWR calls real-time operations, but this isn't relevant or accurate as to Stockton, and particularly whether the project is consistent with the co-equal goal of ensuring a reliable water supply, because the D1641 water quality standards are higher than any level at which impacts will occur to Stockton. And DWR is not required to meet those standards at Stockton's intake or anywhere on the San Joaquin River. So just saying that you can adjust your operations to avoid harm is incorrect and unsubstantiated with respect to Stockton's water supply. Again, it's not relevant, it's not best available science. And if meeting D1641 standards were sufficient or feasible, the department wouldn't have agreed to provide Contra Costa Water District with a substitute water supply of 30 milligrams per liter. So Stockton's comments on the EIR and its testimony in the water rights hearing raised concerns about the effect of numerous constituents that are not regulated by D1641. Bromide is an example. And it's interesting if you look at DWR's evidence and conclusions with regard to bromide and a number of other constituents, they again fail to demonstrate transparency and objectivity that's required by your best available science criteria. Not only was the data that the department relied on for its evaluation of water quality impacts to Stockton fundamentally misleading and inadequate because they used long-term averaging and exceedance probability graphs, but the conclusions that were drawn from that data are in many instances at odds with the data itself, and they're misleading, and they don't meet the best available science requirements for transparency and objectivity. And before you, it's hard to read and see, but I've included a graph from DWR 652, the section that talks about bromide, because bromide impacts to Stockton. Although this is a a graph that's based on the long-term average data, you will note that the orange line, which represents a WaterFix operating scenario, is significantly higher than the black no action alternative line for a substantial portion of this time. And Stockton's expert pointed out in the water board hearing that the text of this report really doesn't fairly characterize DWR's own water quality modeling results. And the text that accompanies this graph characterizes the graph as showing, quote, similar or somewhat higher monthly mean bromide concentrations. But the graph here shows substantially higher bromide concentrations relative to the no action alternative by as much as 100 micrograms per liter for a significant portion of the time. And this is notable because the bromide threshold DWR used was 100 micrograms per liter. Yet their text of the report, the conclusions drawn from this data, concluded that an increase of double the threshold wouldn't have an adverse impact and that increase would be similar. Stockton maintains that it was not objective, it's not transparent, it doesn't meet your criteria for best available science. Quickly, I apologize, this is tedious, but I do want to address a couple of points cited in the determination. We'll follow up in our written comments as well. Some objections by DWR that the staff specifically quoted in the determination citing testimony of DWR's expert Dr. Nader Tarani, as evidence that Stockton's expert used an incorrect chloride conversion factor and thus overstated impacts is really a red herring, because the real issue is not whether Stockton's expert could have made a different choice in the chloride conversion factor that she used in her testimony, but whether the department, in considering project impacts to Delta water quality and making a determination that the WaterFix is consistent with the goal of ensuring a reliable water supply, used best available science. And it's notable that in his testimony, Dr. Nader Tarani did not say that Dr. Paulson had used an incorrect factor. He merely noted that she could have used a different conversion factor, and he cited one example of how chloride levels might have been different if she'd used something different, but he did not say she should have used that factor. And in fact, there is no single conversion factor that's clearly the most appropriate. DWR used only one for the entire delta in its analysis of impacts to Stockton included. And so it made no attempt to tailor its evidence and analysis to the actual site-specific conditions that were relevant to Stockton's water supply. They used a conversion equation for the western delta that assumed that pretty much all of the chloride comes from seawater. Stockton used a conversion equation that was calibrated at a location which has a similar composition of water to Stockton's intake, certainly much more similar than the western delta, and DWR did not do that. Stockton's expert acknowledged the location it used was the one nearest Stockton's intake in terms of the water composition, that it wasn't a perfect match, but it was closer than anything else. It was the best available science. And it was actually more conservative than what DWR used, and DWR does not dispute this, that it was more conservative. And so as a result of that choice by Stockton's expert, the results that I've described today and that are cited in our testimony and our appeal actually underestimate slightly the impacts to Stockton compared to what would have been shown if DWR had gone to the effort of disaggregating all of that long-term monthly data and actually describing and presenting the water quality changes that would be meaningful to an assessment of how this project affects Stockton's water supply reliability. Contrary to the evidence that's cited in the staff determination, draft determination, Dr. Paulson didn't limit her analysis to a comparison with existing conditions. They are evaluated against the no action alternative. That statistics I quoted earlier about the impacts to Stockton are all based on a comparison with the no action alternative. The October 23rd response from DWR regarding impacts to Stockton misleadingly suggests that a final EIR commitment, this 3B31, provides assurance that the department will address water quality impacts to Stockton. And the draft determination doesn't specifically reference this, but because it's in the response and it wasn't entirely clear if the staff had relied on this, I will briefly note that this measure offers no assurance that any of the WaterFix impacts to Stockton will be mitigated. DWR commits in this measure only to assist those in delta water purveyors that DWR determines will have a significant unavoidable water quality impact from operating the water conveyance facilities. And DWR's refused to recognize that this project will have any impact on Stockton's water supply. So this measure does nothing for Stockton. It provides no assurance and no substantial evidence to demonstrate that impacts to Stockton will be mitigated. I guess I would say that if the department intends to rely on this measure, it must clarify when it comes back to you with a revised consistency determination that this measure will be applied to Stockton in a way that fully mitigates the impacts of the WaterFix project. Addressing the impact to Stockton of its lost water supply for all of the days in which the WaterFix causes the chloride levels to exceed Stockton's usability threshold. So just to wrap up for Stockton, the burden of proof is not on Stockton to prove how or to what degree it will be impacted, although we have done so with substantial evidence that meets your criteria for best available science. The burden is on the department to demonstrate that it used best available science and that its determination is supported by substantial evidence in light of the whole record. We believe that our submittals show that it hasn't done that and that the project is not consistent with the co-equal goals or the Delta plan because it makes Stockton's water supply less reliable. You are the entity that is tasked with protecting the Delta by ensuring that projects like the WaterFix are consistent with the co-equal goals in the Delta plan. And in many respects, you are the last resort for Delta communities that will be harmed by the WaterFix construction and operation. And the draft determination appropriately recognizes many of those unmitigated impacts, but we submit that it doesn't go far enough because it fails to recognize the impact to the drinking water supply of the largest municipality in the Delta, 300,000 people in Stockton. And I guess last for Stockton, I'll note that you heard today from the department that it's trying to address long-range problems such as the impact of sea level rise. And I'll note that in trying to solve that problem for its south of Delta water users. It's exacerbating that problem for in-Delta water users. And Councilmember Thompson alluded to that in his questions about the effect of diverting 9,000 CFS of flow from the North Delta. That water is not flowing through the Delta. It will not be available to help push back against seawater intrusion. It'll be leaving Delta, in-Delta users to suffer the effects of sea level rise with no mitigation. And I guess from Stockton's perspective, it's as if the Department of Water Resources is saying, pull up the ladder, I'm aboard. We're going to solve sea level rise for the people south of the Delta who don't want to have to deal with the effects of salinity, and the effects for in-Delta water users will be left to them to figure out. And that is fundamentally unfair, and we hope that when it goes back to DWR that they will that you will direct them through finding that they didn't use best available science or demonstrate consistency with the co-equal goals, that they need to take a harder look at how they can achieve their objectives while not making things less reliable for Delta water users. So thank you for that. That concludes my presentation for Stockton, and I have just a very short few remarks to make for the Regional County Sanitation District. If we could put up the presentation for Group A6, please. It's just a couple slides. Thank you. So the Sacramento Regional County Sanitation District's appeal focused primarily on the policy DP P2, that requires that DWR respect local land uses when siting new water facilities. The requirements are to avoid or reduce impacts to the extent feasible, and the draft determination focuses on whether there's substantial evidence of effective mitigation, and Regional San's position would be that simply doing an alternative site analysis and concluding that there are no feasible alternative locations for the project is not sufficient to demonstrate compliance with a standard that requires that you respect local land uses when you're siting water facilities. The determination seems to focus on DWR's alternative site location. Our position would be, if this truly were the only feasible location to put these facilities, and they will have an adverse effect on Stockton's treatment plant operations and its facilities, then the department needs to show that it has done everything possible to reduce the effects of putting the intakes, and this goes to the intakes, in the location that it cited them. And so far it hasn't done that. It did include a commitment in its EIR in an appendix to come up with an operating plan that would avoid effects to regional SAN, but there's nothing in the record to demonstrate that that's feasible. They haven't coordinated with regional SAN or tried to demonstrate how it could be done. If it can be done, that would be great. That would address regional SAN's concerns. Regional SAN has been before you many times. They are actively involved in the Delta and protecting the Delta and Delta interests. They have consistently advanced the position that the beneficiaries of projects must pay for the impacts of those projects. There will be an impact to regional SAN. The water users who benefit from the WaterFix project should mitigate those impacts, and they should demonstrate to you through the use of best available science that those impacts have been mitigated to the extent feasible before you certify or accept their certification that the WaterFix project is consistent with policy DP P2. And I'll just, on this point, the draft determination does focus on the lack of effective mitigation for other local land use impacts. Regional SAN appreciates that because it's an existing use in the Delta. It wants to ensure that all the uses are protected. This determination is being remanded or the staff recommendation is that you remand the consistency certification to DWR. And Regional Sand is simply asking that it be treated like all of the other existing uses in the Delta with respect to the question of adequacy of mitigation, and that your staff find that as of, we're sitting here today with the record before you, there is no substantial evidence that the DWR has mitigated impacts to the Sacramento Regional Wastewater Treatment Plant to the extent that's feasible. And so we would ask that you just apply that same standard of review and hold DWR's feet to the fire for impacts to the local land use of the Regional Wastewater Treatment Plant, as you did for the other Delta communities and land uses. And that concludes my presentation for Regional Sand, and I'm happy to answer questions about Stockton or Regional Sand's appeals or comments.
Ms. Tabor, thank you. Questions?
It would be fair to say that what you just presented to us is basically a summary of the changes, the feasible changes that you think should be made in the project or in the recommendations of the staff?
I was more specific maybe for Regional Sand. Yes, I think Regional Sand's concerns could be addressed with if it were assured that the impacts to its operations would be mitigated and its facilities. And that there are multiple concerns raised in its appeal. Some deal with how the intakes are operated. Others deal with the financial impact if those operational effects cannot be adequately mitigated. So all of that is addressed in our evidence before the council. It may well be possible that those can be addressed, but so far that assurance doesn't exist. For Stockton, I mentioned when I was here in October, and I think Dr. Lytle's testimony suggested, Stockton feels that it has been treated differently and unfairly compared to some other Delta entities that the department has settled with. If Stockton had the same assurances that Contra Costa Water District has been given about providing an alternative water supply or otherwise mitigating the impacts of the project, it could very well be that Stockton's concerns are fully addressed. The issues Stockton raised in many issues over the years of concern with regard to this project, but it's focused for the purposes of this appeal and in the water rights proceeding on the reliability of its water supply. And it's simply looking to have the impacts acknowledged and mitigated to the extent feasible. We think that the department feels that it's feasible to mitigate it because it's done it for other entities in the Delta, Contra Costa Water District. That might satisfy Stockton.
Thank you.
In your opinion, will if the State Water Resources Control Board issues a change in the point of diversion permit, would that likely address the concerns, the water quality concerns of the city of Stockton?
We certainly hope it will, but right now I couldn't predict how that decision would go. We feel that Stockton and other in-Delta water users have presented a very compelling case, but I couldn't prejudge what the water board would decide on this. So, but I think that goes to the question raised in Regional Sands and Stockton's appeals. This staff is recommending you deny these appeals on the ground that its WaterFix certification is premature. But certainly, I think it goes back to the question that we raised: is it really is probably premature to be here. A lot of these issues might be addressed. The D1641 compliance is an issue that you've talked extensively about. Were the water board to approve a change in that, and who knows when that might be, that issue might come off the table and would be something you wouldn't have to deal with. Were the water board to condition the water rights permits in ways that addressed many of the issues here, it could certainly narrow the scope of issues that your council is required to determine. So we still, we accept the staff's recommendation on that point, but we would say, I think today's workshop only highlights the fact that we feel it's premature to be here before the water board has ruled on that water right change petition.
Okay, thank you very much.
Thank you.
Candace, 25 more minute presentation, good? All right. Then next up will be San Joaquin County et al., Appellant Group A7, represented by OSHA Meserve.
You take that. You take that. So you're going to be controlling it. Good morning. Tom Keeling and OSHA Meserve, representing the Delta counties and local agencies of the North Delta. Like everyone else, and very sincerely, we wish to express our appreciation to the council for this opportunity and to staff in particular for this this terrifically difficult draft determination. I don't know how you slogged through it in such short order, but congratulations. Today we'd like to do two things. We'd like to highlight some information that further supports the findings of inconsistency, and we'd like to provide some information that we believe weighs strongly in favor of reconsidering a few instances as to which the draft determination did find consistency. First, though, a word about the question of prematurity. In our earlier presentations, we pointed out that this proceeding is premature, the incomplete CEQA process, the increasing uncertainty about the role of the reclamation district, the likely conditions that will be imposed by the State Water Resources Control Board in its change petition hearing, the incomplete Army Corps of Engineer permitting process, and in fact, incomplete permitting before the under the ESA and in the Fish and Wildlife Service biological opinion. Could you turn to that briefly?
Yes, and just to highlight that point, since it hasn't...
You need your mic on.
Just to highlight the point regarding the biological opinion issued by Fish and Wildlife Service in 2017, I don't think it's been highlighted here, but that document had a mixed programmatic and project level approach. So that document actually doesn't provide take authority at the federal level for either construction of the intakes and several other major components of this project, as well as operation of the project. So that's another layer of future reinitiation of consultation that the Fish and Wildlife Service expects to have in the future that would likely lead to additional changes to the project.
The bottom line is we believe that further consistency reviews for this project, which by the way is only 10% through its conceptual planning stage, are very likely and will be required. As to each of these uncompleted processes, the Department of Water Resources says, quote, "The department has committed to coordinate with the council through early consultation and determine how the change affects the WaterFix certification and what compliance is necessary for the Delta Reform Act." As to these issues, the draft determination states, quote, "The council expects the department to pursue an early and robust consultation." That's from page 10. "The council strongly encourages the department to pursue an early and robust consultation," also from page 10. "The council reiterates that it strongly encourages the department to pursue an early and robust consultation." That's page 11, having to do with the board hearing. And, quote, "The council expects the department to pursue an early and robust consultation in the event that changes to the project are approved." That's page 9, footnote 5. We submit that this approach does not address the prematurity of this proceeding. Rather, it creates vague and unenforceable expectations with respect to future proceedings. This is not a response that makes any sense to the prematurity of this proceeding. Moreover, the draft determination leaves unanswered a series of questions. For example, what are the triggering events for these, quote, early and robust consultations? In fact, what is meant by early and robust in this context? Would DWR's assurances on this point be legally enforceable by the council or by others? Could the council itself initiate such an early and robust consultation if it saw fit to do so? What consistency determination authority would the council have in the context of such a consultation? What sort of public notice and public participation would there be? Something that's particularly important, as many of these changes that are anticipated will be substantial in our view. And what about assurances that the present prohibition against ex parte communications will remain in place between now and the completion of any later consultation? We think that instead of the approach taken in the draft determination, the council should confront the prematurity of DWR's consistency determination head-on and remand the matter to DWR on the ground that it's simply premature. Alternatively, we think the council must demand enforceable commitments if it's not going to remand on prematurity. For example, we think the council in that case should establish clear and enforceable triggers for these, quote, early and robust consultations. We think the council should require DWR to initiate the early and robust consultations. We think the council should provide a cost-effective procedure for commencement of early and robust consultation by the council itself. We think the council should provide that any later consultation, whether it's early and robust or not, will be deemed a continuation of this proceeding subject to the continuing prohibition against ex parte communications. That's a big concern of ours. We think the council should provide for meaningful public notice and participation, and within this proceeding, provide appellants the right to initiate such a consultation if both DWR and a future council should not do so, despite the occurrence of a triggering event. Ms. Meserve.
Thank you. I'll go through, I have a lot of slides and I'm sure I won't get through them all, and we will submit something in writing in more detail, so please don't be upset with that. I'll try to dwell on the ones with the pictures. I know it's been a long day. So first of all, just to touch on the mitigation measure issue, policy GP1B2 is very important. The consistency determination should have explained how each mitigation measure that is actually required of this project is as effective as the Delta Plan Program EIR mitigation measures. The crosswalk table really doesn't do that. It just throws out what the relevant mitigation measures might be without going into the detail of whether they are as or more effective. So We would encourage the council staff to look at the crosswalk table again and really consider whether DWR has carried its burden to meet the requirements of GP1B2 with respect to showing that equally or more effective, because what the crosswalk table really does is just provide a list of things you might look at, and then the public, the council, the appellants are left to go and try to characterize how they may or may not be the same. I was just going to touch on two about special status species and the conversion of ag land today. Looking at the program EIR mitigation measure 4-2, it requires several things: selecting sites to avoid special status species, scheduling construction to avoid special status species, and then compensating for those things. Now, here in the citing, this is just from the EIR, but it shows that basically the whole delta's great sandhill crane habitat area. The foraging is the green, and then the actual roosting and nesting sites are in the blue and the red, and you can kind of imagine where the tunnel cuts down right through the middle of all that. And this is just one species, obviously, within hundreds of species that occur in the Delta that are important to the communities and to the environment to sustain now and in the future. But, the crane is important, too, because the PEIR mitigation measure kind of assumes that you could get take authority as a third option once you did the other things. And for the crane, oh yeah, it does go dark. There really isn't any commitment to do that. And in particular, the construction is planned right now from the documents in front of us in the conceptual construction plan during the winter crane season, which is directly in conflict with the mitigation measure that the Delta Council adopted. Also, just thinking about best available science as well, the project says it will rely on bird diverters on new power lines they must construct in order to power the project, which does not run on gravity, in fact, because it does require a lot of power to construct and also operate, so that's kind of a misnomer. But anyway, the study relied upon by DWR was actually in Colorado, and it's hard to read there, but that big bar chart is how many days you might have fog in the Delta in the winter, and the little bars are how much you might have fog in Colorado, where this study comes from. In any case, the bird diverters in this study are assumed to be effective 60% of the time. So just imagine that there's 10 cranes flying on Staten Island one day, and if it's 60% effective, 6 of them would be prevented from hitting the line and 4 wouldn't. There are other measures within AMM 20 that are all modified by if feasible and other things, kind of a list of options approach, but there really isn't substantial evidence anywhere in this record about how AMM 20 in particular meets best available science or is equally or more effective than the mitigation measure, or even more importantly, would comply with the no-take requirement of the fully protected species sandhill crane. So I think that's one area where the draft determination could dig a little deeper into the evidence that has been developed around the sandhill crane as an example. Now, with respect to conversion of agricultural land, obviously a very important issue for the counties and individuals in the Delta and really statewide. Delta is the largest swath of contiguous prime farmland in the whole state. It's one of the only areas probably where long-term we will be able to protect a huge amount of prime farmland in the long term if we don't have this project coming through and taking out thousands of acres directly and then indirectly. But looking at mitigation measure 7.1 from the program EIR, it's talking about designing the project to minimize the impacts on ag, then doing ag easements, and then also avoiding interference with the ag operations. Now, what we see with the mitigation measure put forth by DWR AG1 is that it kind of has an either-or approach. It says, oh, well, we will try to do this alternative way of kind of a list of measures that might be more adapted to the Delta, which is actually a great list of things to think about doing and which may be helpful in certain situations. And then it says, if that's not feasible, then we'll do the easements. Your mitigation measure 7-1 doesn't allow that either or approach. So I would definitely, and in addition, the mitigation measure issue is also relevant to whether the reduction in conflicts with local land uses under DPP2 has been accomplished, particularly in the siting issue. With respect to the best available science, we agree that the timeliness requirement for the higher risk climate change scenarios was not considered. And I just want to point out that the bit of modeling that was done in, I believe, 2013 regarding a longer range projection from 2060 was actually for the BDCP Alternative 4, which is a completely different project that had over 100,000 acres of habitat in it, and so it really had quite a different effect. So there's never been a more recent attempt to try to look at the issue of what long-term 2060, which I believe there was a question around, is if this project is meant to be in place for 100 years, for a long time, does this project even attempt to plan for that? So, and I've just listed some of the sites here that show that really all they've looked at is a 2025 or a 2030 climate scenario for the currently configured project. Now, the other point I want to make about best available science is this aggregation issue. Trying to aggregate averages, and you heard from Stockton about this just now, but it kind of permeates all the different water quality concerns that folks have about what the difference will be when about half the average flow of the Sacramento River would be diverted into tunnels at the very northernmost portion of the Delta and from the freshest water coming into the Delta, really, in large quantities, the Sacramento River. And really, aggregation, you might look at everything together and say, oh, well, on average, if you go from 1922 to 2003, it's only 4.6% of the time. But it's really important to break that out by month and also by day, as was explained with respect to Stockton is similar to someone trying to farm in that if I have baby plants that have just been planted and I apply very salty water to that, in that particular moment, that may have a large impact on the crop yield at that time. And so this averaging really doesn't do justice to the kind of on-the-ground effects of on both the on agriculture, as well as this, as I mentioned, relates to best available science, and also the ability of DWR to try to show that they can meet your flow requirement, ERP1, to at least meet D1641. And I heard some discussion this morning about how, well, with respect to, say, the Contra Costa chloride standard, that if you looked at the actual data, it hadn't been exceeded all that much. But I believe that the draft determination really focuses on the modeling that DWR provided, and that the modeling showed that there would be exceedances. And so I think that was a little bit misleading, that discussion this morning, and I'll try to address that more in writing. Very concerned also about the best available science or lack thereof for harmful algal blooms. I just want to emphasize there that the timeliness and other factors for best available science were not met. There was an excuse made that there wasn't a Delta-specific model available. I think with the amount of resources being poured into this project and the potential for this project to dramatically change the hydrology of the entire Delta, and how concerning harmful algal blooms and cyanobacteria in particular are that it may have been appropriate to develop a model for this. And the modeling that was relied upon by DWR was built in order to try to measure things like compliance with D1641. And so it was really an adaptation to try to pick parts of that model and try to see what could be done in terms of inferences for cyanobacteria formation. So this, in addition, it is not timely because that modeling that was relied upon by Dr. Bryan and in the EIR, for instance, actually was looking at a different model run, not CWFH3+, which is the current proposed operating scenario. And this also, and I just put the picture of the boat in there to emphasize that cyanobacteria is not just a technical issue, it's also about how people will they still be able to experience the delta in a post-project world in a way that, and be able to swim, fish, drink the water, etc. Now, Mr. Schutz discussed with the adaptive management. We would like staff and the council to take another look at that. The adaptive management plan is very general and really does not have all the components in it that are required by the council's policy. And in particular, one thing to focus on is whether there's any role at all for stakeholders. There really isn't in this plan. I think the the draft determination refers to some other documents that maybe assist in adaptive management, but I think Mr. Schutz effectively pointed out that those other things like the JPA or whatever, if there's a requirement for what needs to be an adaptive management plan, we need to look to the four corners of the plan, and having some references to other things that may happen by other groups, such as the construction JPA, is really irrelevant to that inquiry. On the flow objective, there are issues with obviously with best available science in addition, and with respect to the to WRP1 applying to the project, it certainly does increase the potential for export. So you've got about 11,280 CFS potential for export right now with your existing projects. It goes up to almost 15,000 CFS with these new diversions. So this is just a picture that shows that this is an increase. And in addition, may also want to consider the fact that there is an ongoing process that hasn't even started that is challenging the fact that that Bureau and DWR permits on the Sacramento River expired years ago, and there's been protests filed on that, and that's been put on ice. So the idea that somehow this is an existing water right is really not correct. I'll skip over these. I think something that it kind of cross-cuts across a lot of the council's policies, and Ms. Tabor commented on it as well, and I think we really need to look at how are we implementing the co-equal goals, and what about water supply reliability for in the Delta? It shouldn't just be about water supply reliability for outside the Delta. And in addition, the respecting local land uses DPP2 also requires us to protect that agricultural water quality, municipal water quality, and all those values within the Delta. Now, with respect to the agricultural water use, there is the ag water standard in the South Delta. Unfortunately, the Water Board's looking at making that standard more relaxed, which is going the wrong way. But the one thing that we don't think has been done with this project and doesn't meet best available science is there never was any study of what the long-term implications of having even slightly elevated levels of salinity in the Delta on agriculture would be. And I think this was also touched upon by others, and it's kind of permeates the whole story about what this project is, but there's nothing in this project that requires it to take more water when it's wet and less water when it's dry. And this was an important point in the recommendations, which I know aren't required here, but I think even looking at water supply reliability and trying to implement the co-equal goals, there should be something in this project that requires you to take more when it's wet and less when it's dry. And if you look at that red line that's going diagonal, that could be like some kind of permit term that would say, hey, you only take water when there's a lot of outflow. There's nothing like that here. Instead, the maximum amount of diversions would be that purple line going straight across, and then there's other limitations that about what the projects could take out, but they don't want to be subject to the inflow to export ratio, and they are only proposing 5,000 CFS minimum bypass during the fall months when we're most concerned about water quality, and our farmers are needing water as well for finishing up their crops. So there's no reason to think that these new diversions would be excluded from the ratio. And with that, I just want to go to a picture about respecting local land uses. I'm going to skip over that. This goes right through the heart of the Delta. It wasn't designed in the first place to respect local land uses. So we need to go back to the drawing board and think about how can we do these things in a way that respects local land uses. And we would ask that the council remand for these and other reasons so that that could be done.
Does that complete your presentation?
Yes.
Thank you both very much. Questions of the council? Okay, then at this time, we will take a 15-minute break, and we will reconvene at 2:48. 2:48.
To be exact.
Fix it. The two things I'm going to talk about is that the WaterFix is not consistent with the Delta Flow Objectives policy for two reasons: the absence of the U.S. Bureau of Reclamation and levee failures. The Bureau's failure to make a commitment that it will operate the WaterFix in compliance with the State Board's D1641 flow objectives is a fatal deficiency. As the staff's draft findings state, in order to demonstrate consistency with ERP1, a certification of consistency must be supported by substantial evidence that demonstrates that the project will comply with D1641. And we believe will is the key word. May comply is not sufficient to support a certification. If the project operators are not sure whether the WaterFix will be operated in compliance with D1641, then the project operators have no business seeking certification of the WaterFix. In that event, the WaterFix is simply not ripe for certification. As the WaterFix currently stands, neither DWR nor any one of us can be sure that the Bureau will, in fact, operate the WaterFix in compliance with D1641. The Bureau might, but again, might is not good enough to support a certification. Unlike DWR, the Bureau has not yet approved the WaterFix. It's undisputed that the Bureau has not yet issued a record of decision for its EIS for the WaterFix, declaring that it approves the WaterFix, i.e. that it actually wants to carry it out. Much less has the Bureau made any confirmation whatsoever that it wants to carry it out in a manner that fully complies with D1641. Accordingly, at the present time, there is zero evidence in the record confirming that the Bureau will, in fact, operate the WaterFix at all, much less operate it in compliance with D1641. Any such operations are purely speculative. That wouldn't be a problem, except for the small fact that the WaterFix has been presented in every respect in these proceedings as a joint project operated jointly by both DWR and the Bureau. Let's see here. Accordingly, without any evidence, much less the requisite substantial evidence that the joint operator of the WaterFix will indeed operate the WaterFix in compliance with D1641, DWR certification must be rejected. Thus far, DWR has only made it halfway towards demonstrating that the WaterFix will in fact be operated in compliance with D1641. DWR has in effect jumped the gun and prematurely sought certification before its co-operator was ready to join in that certification and ready to make the essential joint commitment that it will operate the WaterFix along with DWR in full compliance with D1641 as required by the Delta Plan's flow objective policy. DWR's premature certification must therefore be rejected on this ground. So we request that the staff revisit that. I think they said, well, we can just deal with the Bureau later, but because it's a joint project, I don't think you should do that or can do that legally. There's no substantial evidence backing up the Bureau's commitment. Now switching over to levee failures, this is a favorite topic of mine. In the Delta, the Central Delta South, we live with levees. Levees are our life. We do everything we can to maintain the levees and keep them strong. We don't want them to fail any more than the exporters. Trust me on that. People's livelihoods are at stake in the Delta and depend on those levees. So providing a method to address anticipated levee failures that cause significant degradation of the water quality at the project's existing Southern Delta export pumps is one of the primary touted benefits of the WaterFix. As we previously explained, the method DWR came up with to address those failures will violate the D1641 flow objectives, and therefore that method cannot be found to be consistent with those objectives and must be rejected. Now, this is not a situation where DWR says, look, don't worry about it. We're going to operate these projects in a manner that complies with all the standards so you're not going to be hurt. This is not that situation. They are telling you that they are going to violate the standards in the event of levee failures. And I want to explain why really quick, and then how staff handled that was very interesting and I think needs to be adjusted. Real quick, the problem DWR is trying to address with the WaterFix is when one or more levee failures cause the water quality at their Southern Delta intakes to become too salty for them to export the water. When that happens, i.e. when the water quality becomes too salty, DWR and the USBR are necessarily in non-compliance with the D1641 flow objectives. That is because if they were in full compliance with those objectives, the water quality at those intakes would not be too salty for them to export, because those objectives ensure that the water is of adequate quality. Thus, the problem DWR is trying to address with the WaterFix is when one or more levee failures cause DWR and the USBR to be in non-compliance with the D1641 flow objectives. Now, DWR has two choices in that situation of noncompliance. They can allow Sacramento River water to flow into the delta and help meet those objectives, or they can take the Sacramento River water away from the delta and put it in the tunnels and export it out of the delta. And I don't need to tell you what choice they picked, but I'm going to tell you anyway. They picked the second choice, to take that Sacramento water and not use it to meet the standards, but to export it out of the delta. And just, this is a recap of that. In the event levee failures significantly degrade water quality and cause DWR and the USBR to be in non-compliance with the D1641 flow objectives, DWR came up with the brilliant idea that rather than allow Sacramento River freshwater to flow into the delta to meet those objectives and freshen it up so it can resume exporting that water, DWR could instead simply take that Sacramento River freshwater and divert it directly into the WaterFix tunnels for export. Because it could take significant time to freshen up the delta after levee failures, with the WaterFix's tunnels, DWR could avoid having to wait for the delta to freshen up and immediately start exporting water through the tunnels after such failures. For DWR's delta export contractors, this most likely sounds like a wonderful use of the tunnels. This sounds like, why didn't they think of this sooner? Unfortunately, for such exporters, such use of the WaterFix's tunnels after levee failures is completely 100% prohibited by D1641. That is because D1641 prohibits DWR and the USBR from exporting any water from the delta through the WaterFix's tunnels or otherwise when DWR and the USBR are in non-compliance with the D1641 flow objectives. Thus, if levee failures significantly degrade water quality and cause DWR and the USBR to be in non-compliance with the D1641 flow objectives, DWR cannot lawfully export any water through the WaterFix's tunnels. Thus, to the extent D1641 is complied with, the WaterFix's tunnels are useless after levee failures. The only way DWR can make the WaterFix tunnels useful in the event levee failures significantly degrade water quality and cause DWR and the USBR to be in non-compliance with the D1641 flow objectives is to violate D1641's prohibition against any exports during such non-compliance. Compliance with the Delta Plan's flow objectives policy, however, requires DWR and the USBR to demonstrate that they will operate the WaterFix in compliance with D1641. Thus, there's a monumental problem for purposes of the instant consistency determination. DWR and the USBR are telling you and everyone else in their certification that they are planning on using the WaterFix's tunnels after levee failures in violation of D1641. Such planned use of the WaterFix's tunnels should obviously not be sanctioned. Now, how does the DWR and the council staff address this inconsistency? They both effectively concede that DWR and the USBR must continue to comply with D1641 in the event of small or large levee failures, and that exceptions to such compliance will have to be obtained from the State Water Board to authorize the use of the WaterFix's tunnels to export water, notwithstanding the fact that D1641's flow objectives are being violated. So they are agreeing to the point we're trying to make. The point is the intended use of the WaterFix's tunnels to export water from the delta after levee failures will violate D1641 and require an exception to compliance with D1641. Hence, the intended use of the WaterFix to improve the reliability of water supplies for delta exporters in the event of levee failures cannot be sanctioned as being consistent with the delta flow objectives policy, because that policy requires compliance with D1641. Such use must therefore be rejected. Now, that sounds simple enough. However, there is a twist, and this is the twist that the staff hung their hat on, which I think they should go back and fix. The council staff suggests that it's not a deal breaker that DWR's proposed use of the WaterFix's tunnels will require an exception to D1641, because the department's task in its certification is to show that California WaterFix can comply with D1641 in the conditions in which the decision was designed to function. The staff agrees with DWR that D1641 was not designed to function in the wake of catastrophic levee failure and salinity intrusion. Now, my own jaw dropped when I heard DWR come up with this reason. Unsurprisingly, neither the staff nor DWR, however, cite to any authority from the State Water Board or otherwise that suggests that any, much less all, of D1641's numerous flow objectives and requirements on DWR and the USBR and on others are somehow not designed to function in the event of so-called catastrophic levee failure and salinity intrusion. If the State Water Board did not speak to the topic, which we believe it absolutely did not, then how does one define catastrophic levee failure and salinity intrusion? And who should define those terms? DWR, the Council, the State Water Board? Once those terms are defined, is it only sufficient for consistency purposes for DWR to seek exemptions from D1641 after such catastrophic levee failure and salinity intrusion, but not after any lesser type of levee failure or salinity intrusion? This opens a can of worms. In going down this road of tolerating exceptions to compliance with D1641 in circumstances that the Council believes D1641 should not apply is going too far. The Council's Delta Flow Objective policy is clear and easy to implement. The project proponents must demonstrate that they will operate the covered action in compliance with the State Water Board's then current flow objectives, which currently are D1641 objectives. Here it is undisputed that DWR and the USBR intend to operate the WaterFix in non-compliance with those objectives. Such intended use should therefore be rejected. If DWR, or here's a solution to this problem, if DWR and or the USBR want to change the State Water Board's D1641 objectives to make exceptions for catastrophic levee failures or other circumstances, then they can take appropriate action to petition for such changes. There is a process to do that where anybody could go and request amendments to D1641. The instant certification process, which requires DWR and the USBR to demonstrate full compliance with D1641 objectives as those objectives presently exist, is not the place to make those exceptions. For all of these reasons, the Council should reject DWR and the USBR's intended use of the WaterFix to violate D1641 objectives after levee failures as inconsistent with the Council's Delta Flow Objectives policy. DWR and the USBR should accordingly eliminate this use of the WaterFix in connection with any future recertification of the WaterFix. And in 10 seconds, if DWR can successfully change the D1641 standards to allow them to violate them during levee failures, then they could come back and recertify based on those changed standards. But right now, the standards don't allow it, and you shouldn't allow them to violate it. Thank you.
Does that complete your presentation?
Yes.
Thank you very much. Questions for Mr. Nomalini? Very good. Thank you very much.
Thanks.
Next up, County of Sacramento, Sacramento County Water Agency, Appellant Group Number 9, William Burke.
Good afternoon. Am I coming through? Sounds like I am. My name is Bill Burke. I'm representing the County of Sacramento and the Sacramento County Water Agency. I guess I'm the one appellant who doesn't have a PowerPoint, so I won't trouble you with having to read anything. But I will be submitting written comments. When I submit my written comments, I'll have all the page citations I'm about to read off right now. My comments are going to be directed towards some issues that where staff went against arguments that we made previously, although I am pleased and encouraged that staff did seem to agree with us on some other arguments. So in particular, I'm going to be looking at policy DPP2 that involves the project's respect for local land use, or whether the project respects local land use. And mostly I'll be looking at the issues on agricultural impacts or impacts to agricultural uses, conflicts with ag uses, and a little bit briefly about transportation impacts to land uses. So certainly wouldn't hurt to read the reg one more time. Section 5011A, water management facilities must be sited to avoid or reduce conflicts with existing uses or those uses described or depicted in city and county general plans for their jurisdictions or spheres of influence when feasible. I'm going to start out with something that might be viewed as a technicality, but it really isn't. At page 131 of the draft staff report, there's a reference to the permanent conversion of ag land, and I believe the figure there used is about 3,900 acres of ag land. Per the supplemental EIR, that is up to 4,305. So it's more than a technicality. That's 400 more acres, and in total, massive amount. And we did mention that updated figure in our presentation here a few weeks ago. At page 132 of the staff report, there's a discussion about DWR's project refinements or changes to the project to show how kind of the project evolved to reduce conflicts on local land use. In that discussion and in the department's certification documents, there's a table, a project refinements table that shows a reduction of 1,215 acres of impacts to ag land. I would just ask staff and the council to seek specificity and clarification on where those 1,200 acres of reduction came from. There's a discussion about how some of the design aspects of the facilities were changed, but there's no specific explanation of how 1,200 acres of ag impacts were reduced. So these, I see these as, I'm still on page 132, these were project design modifications as described in the project refinement section of the consistency certification. And these are not equivalent to siting decisions, which is the focus of the policy. DWR's project refinements discussion does not explain how this relates to siting of the facilities other than in terms of downsizing them. Project refinements do not explain how the various project facilities have been cited to reduce conflicts with ag land. One other specific point to make about that discussion, that narrative, is there's a reference to a change in the sedimentation basins, that the basins were originally going to be concrete, I believe, and then were changed now to what they call earthen bays. It was not clear to me how that change resulted in any kind of reduction in the footprint of the facility. So at pages 92 and 105 of the staff report, and in particular, I'm looking at the third full paragraph at page 92, the staff report discusses the rationale of the siting decision in terms of avoiding impacts to, quote, existing structures, businesses, historical interests, and current use of the land, end quote. But it does not explain or show how the project facilities were cited to reduce conflicts with ag land, and that's because the reality is it can't make that showing because the project facilities are not cited to reduce conflicts with agriculture. In fact, the direct impacts of citing the proposed facilities, especially in Sac County, are almost completely on ag land and ag uses. This point also refers to page 99. There's a handful of bullet points. And in the discussion of intake siting, there's no mention of how siting of facilities would avoid or reduce conflicts with ag land. Now I want to get into the ag mitigation measures. That's mitigation measure Ag 1 and its component parts, its 3 elements. DWR has failed to show how mitigation measure Ag 1, that's the Ag Land Stewardship Plan, meaningfully affects the siting of project facilities and how Ag 1 would reduce conflicts with ag uses. This is because the measure in all of its components is voluntary, optional, indefinite, and does not constitute an enforceable commitment. Measure Ag 1A says that it promotes ag productivity. This is not a definite or enforceable commitment. The consultation is voluntary and depends upon cooperation of multiple other private and public entities. Measure Ag 1A also requires DWR to identify impacted lands and consider if the project is consistent with land use plans. Well, with respect to the intakes, the intermediate forebay, and the RTM areas in Sacramento County, we already know that it is not. Lastly, with respect to Ag 1A, it requires DWR in consultation with various local agencies, landowners, and federal agencies to perform analysis. That's the quote from the report, perform analysis to determine, it's from the EIR really, perform analysis to determine if they can reduce the project footprint or identify other parcels that would minimize impacts on ag resources. To borrow a concept from Sql law, this would be a deferral of the formulation of mitigation, requiring DWR, the project proponent, to go and figure out what the mitigation is at a later date. And that is another thing that makes this measure illusory. And the record contains no evidence that any of the facility footprints would or could be meaningfully reduced at this point, or that any parcel other than ag designated parcels would be used for the 3 intakes or the intermediate forebay. So the illusory nature of measure Ag 1A immediately requires a default to measure Ag 1B, and if the land does not involve a Williamson Act contract property, then you have to default to measure Ag 1C. That is the optional ag land stewardship approach, and right there in the name of that mitigation measure is the word optional, which again reflects how it is not a definite or concrete commitment. As with the ALSP, the optional stewardship approach lacks definiteness in that DWR determines the nature and form of the necessary additional mitigation, and the implementation of the measure depends upon a voluntary agreement with local agencies and property owners. At page 134 of the staff report, the report states that ALSPs would provide a greater opportunity to avoid conflicts than one-for-one ag land conservation through easements or planning requirements. This is not the standard that the department is required to meet. That is comparatively demonstrating a greater opportunity to avoid conflicts. Rather, DWR is required to show through substantial evidence that the project infrastructure will be sited to reduce conflicts with existing uses. DWR has not made the required showing for the reasons I just explained. I would also note that these mitigation measures, it's virtually impossible for them to achieve complete avoidance of conflicts with ag land. All we're looking at this point is whether or not the measures can reduce those conflicts. The draft staff report notes DWR's position that ag conservation easements have limited value as mitigation. If this is the case, then DWR cannot rely upon these conservation easements as a component of the optional stewardship approach or as a last-ditch option for mitigation. Page 134, still, the second full paragraph. The report states that use of ag land stewardship plans provides substantial evidence to support DWR's finding that they attempt to avoid conflict with ag land use where feasible. Again, a quote, unquote, attempt is not the proper standard, much like the use of the word opportunity to mitigate. Policy DPP2 requires that the facility must be cited to reduce conflicts. The use of the word attempt reinforces the problem with ALSPs and the optional land stewardship approach being indefinite. And the second full paragraph at the end, still on page 134, it notes that the ALSP would include avoidance and on-site mitigation measures, citing project features to minimize fragmenting or isolated farmland. Well, the sheer scale of the impacts requires DWR to describe how such measures would significantly or meaningfully reduce the ag land conflicts created by the construction of major infrastructure. Relative to the conflicts created, these measures would likely be nominal or superficial reductions in the conflict. Otherwise, this evidence should not be considered substantial. I do want to note on page 135, the first full paragraph, there is a conclusion that is potentially inconsistent with another passage in the staff report. The staff report justifies the permanent loss of ag land by noting DWR's intention to provide compensation to property owners for economic losses. This justification is potentially inconsistent with the staff report's treatment of the same mitigation approach at page 101 with respect to land use conflicts of constructing the water conveyance facility. There, the staff report critiques DWR's reliance on the payment of compensation as mitigation by noting that no further description of this compensation is provided. The staff report thereafter immediately finds that no evidence in the record is cited which supports the conclusion that that impact would be reduced to the extent feasible. The staff report should reconcile these two conclusions. Now I want to get in the minute and a half I have left, to traffic impacts, still within the context of the respect for local land use and conflicts with local land use. The county and especially the county submitted pretty detailed evidence and argument on traffic impacts. We did it mainly in the context of the discussion of co-equal goals. We didn't specifically do it in the context of this category, this policy on land use impacts, but the substance of our arguments is equally relevant. In particular, we submitted the written testimony of the county's Chief of Transportation Maintenance and Operations, Reza Mogisi, and he had his own critique of the transportation mitigation measures. And the staff report doesn't mention our evidence, is one reason I'm bringing this up. I think that our arguments are equally relevant to this discussion, and staff should take a look at what we presented. And in our live presentation here a few weeks ago, we did mention traffic impacts in the context of this policy, DPP2. We noted that the transportation mitigation measures place a burden on local agencies to mitigate impacts that will be exacerbated by the WaterFix construction trips. And we also pointed out that Measure Trans 1C is dependent upon voluntary agreements and therefore does not constitute an enforceable commitment. At page 130 of the staff report, your staff calls for appellants to specify how DWR has failed to avoid or reduce impacts, or that additional reduction in impacts is feasible. Our evidence has shown that. 2 points to make there. With respect to Measure Trans 1B, that's the measure that purports to limit construction activities so that traffic levels remain below acceptable LOS levels of service. In the expert opinion of our witness, he found the measure to be inefficient, impractical, and unenforceable. And we also identified feasible mitigation in the form of a commitment from DWR to repair and maintain the high-usage Delta roads before, during, and after project construction.
You're about done.
And that is, I had one last comment, if that's okay. Page 92, this is a miscellaneous comment. Staff report lists project refinements as evidence of reducing land use conflicts, including reduced project features on Staten Island. This is misleading because in the supplemental EIR, the project was revised to expand a shaft facility on Staten Island from 10 acres to 39 acres, and it also adds a 10-acre safe haven work area to Staten Island for a total of 3 such areas. So I think any changes that are argued in terms of downsizing the impacts to Staten Island should be read in context with the additional project elements that were added in the supplemental.
Does that conclude your comments?
That does, thank you.
Thank you. Any questions, Mr. Burke? Okay, thank you very much. Last presenter will be the Delta Protection Commission. And I believe Supervisor Villegas and Eric Vink are coming to the table.
Good afternoon, Mr. Chair, council members, and staff. My name is Oscar Villegas, Yolo County Supervisor, but I want to make clear today I'm here on behalf of the Delta Protection Commission with some prepared comments. I'd like to begin by, first of all, saying that I'm going to be less than 5 minutes for what that's worth. So my comments will be brief, and I don't have a 100-page PowerPoint. All right, just want to make sure. All right, so the Commission, first of all, appreciates the diligent effort made by Council staff in reviewing the consistency, determination, the appeals, and the accompanying information. We especially appreciate the careful review of our comments. At the Council's draft, staff recommendation acknowledges the legislature has found that the Delta Protection Commission, I know you've heard this morning, but it seems like it might have been a month ago, but it was stated this morning, and it's worth underscoring. So I just want to briefly say that, in quotes, the appropriate agency to identify and provide recommendations to the Delta Stewardship Council is the Delta Protection Commission, as the Delta Stewardship Council develops and implements the Delta Plan. All right. The Public Resources Code further states that the Commission may review and provide comments and recommendations to the Delta Stewardship Council on any significant project or proposed project within the scope of the Delta Plan, including but not limited to, and I wanted to clarify that point because there was some confusion about that this morning, but not limited to actions by the state and federal agencies that may affect the unique cultural, recreational, and agricultural values within the primary and secondary zones. All right, the code also says, in quote, the council shall take into consideration the recommendations of the commission if the council, in its discretion, determines that the recommendations of the commission is feasible and consistent with the objectives of the Delta Plan, and for the purposes of this division, the council shall adopt the recommendations. So the commission believes that the council has correctly recognized the commission's statutory authority to make recommendations, that it's quite broad and not limited. So I wanted to underscore that because that might have gotten lost in the translation over the course of the last several hours of testimony, so thank you for considering that once again. So the Commission's unique position makes it well-suited to recommend actions that may avoid, reduce, or mitigate impacts to the cultural, recreational, and agricultural values of the Delta. So the Council has recognized that it is not required to agree with the Commission recommendations concerning actions within its scope of the Delta Plan. The Council can reach its own determination as to the feasibility of the implementation of any Commission recommendations, and indeed it has taken that path. The Commission has always taken seriously its statutory role to advise the Council on how best to protect the unique Delta values, beginning with the development of the Economic Sustainability Plan and the subsequent recommendations for inclusion in the Delta Plan, and continuing with the ongoing involvement that the Commission staff have with Council staff in reviewing Delta development proposals. The commission reviews all covered actions submittals and ensures that any previous comments made to protect proponents are also conveyed to the council, assuming that our concerns were not already addressed by the project proponent. This is certainly the model we followed on the California WaterFix, extensive comments during the environmental review process, and then conveying similar comments to the council as part of the statutory role to advise the council on significant projects that would impact the Delta as place. I'd like to highlight specific areas where the council staff, in finding for appellants, concurred with the commission's conclusions on the inconsistencies within the Delta Plan to DP2, respecting local land use when siting water facilities. So these areas include, first, land use conflicts within the existing Delta communities, in particular impacts to community character and how the proposed community benefit fund would reduce project impacts. Number two, cultural historical resource impacts, in particular impacts to legacy communities, scenic byways, and cultural tourism. And third, parks, recreation, and traffic impacts, and in particular impacts to recreational boating and recreational access due to construction traffic. So the most important areas of concurrence relate to the feasibility and the enforceability of mitigations proposed by DWR. The council staff draft determination provides the opportunity to overcome fatal flaws with respect to Delta's place. The commission trusts that its recommendations for mitigating California WaterFix impacts to cultural, recreational, and agricultural values of the Delta consistently offered dating back to the BDCP iteration of this project can inform DWR's future planning processes. There are also areas where we disagree with the council staff conclusions. For example, agricultural impacts. The Commission suggested utilization of the Delta Plan EIR mitigation measure 7-1, mitigating farmland loss by protecting other farmland on a 1-to-1 ratio as a means of mitigating the significant and unavoidable loss of nearly 4,900 acres of important farmland, the very foundation of the Delta's agricultural economy. Council staff concurred with DWR's contention that agricultural conservation easements would impose relatively few restrictions on farmland within the primary zone because the primary zone is already largely precluded from development. While that is true, it ignores the more than 135,000 acres of important farmland in the Delta secondary zone, lands that are subject to development pressures. It is entirely appropriate for DWR to mitigate the nearly 4,900 acres of important farmland by acquiring agricultural conservation easements on land within the Delta secondary zone. So in anticipation of what I think may be a question, I'd like to reiterate on behalf of the Delta Protection Commission, notwithstanding our comment letter that was submitted in October, that we stand ready to continue to pursue a solution that is not at the expense of the Delta's agricultural, recreational, and cultural values. And so that offer still stands. What I would like to do is defer to Eric Vink, just a very brief comment that he has regarding the community benefits conversation that ensued earlier this morning.
Thank you, Vice Chair Villegas and Chair Fiorini and council members. There was discussion from the council this morning about the Community Benefits Fund, and I just wanted to add a little bit of information on that. It is certainly well, first off, to note that the Commission's advocated going back to our EIR comment letter on BDCP for a Delta compensation fund that in our formulation is really designed more to respond quickly and to immediate needs that are created through construction activities throughout the Delta region. We know that there will be impacts to people. We know that it can be a very long and lengthy process to go through a claims process through a public agency. And so that was the thrust of our recommendation for a Delta compensation fund. In many respects, it's not too different from a community benefits fund, but we have been consistently asking for that in our EIR comment letters. And it's true, I did have preliminary discussions, conversation with DWR staff about the proposed community benefits fund. The idea was presented as a concept without any details. I've asked for additional details. What will it cover? Who will administer it? How much is the project proponent willing to invest in the fund? I don't have answers. I'm still waiting for answers to those questions. But because of the conversation this morning, yes, there has been a preliminary discussion. No, there have been no details proposed by DWR nor the project proponent.
Does that complete your testimony?
That
Okay,
completes it. Thank you.
Any questions of the Delta Protection Commission?
Just a quick question. Sir. Eric, when did the state approach you on the Community Benefits Fund? Was that recent?
Sometime within the last year.
Okay.
Okay, gentlemen, thank you very much.
Thank you.
That completes the presentations. Can I see a show of hands of those of you who are here that would like to provide public comment? Okay, all right. Well, I want to afford the time for that. Council members, before I call upon those who wish to address the council, I'd like to exercise the chair's prerogative and offer some observations. First of all, I agree with many of the presenters today. I'm very pleased with the work that our staff has done. Jessica Pearson, Dr. John Calloway, Jeff Henderson, Dan Constable, Ryan Stanbra, Bethany Payne are all team leaders who have helped to prepare the staff draft that we have been reviewing, and I'm impressed and appreciate your team's help as we've waded through the record before us. The document, the staff draft findings, reflect an extraordinary effort to provide a thorough analysis, and on behalf of the council, I wish to thank each one of you and, again, your team members. As I've listened to the staff presentation, the parties today, the notion of time or timing that we keep hearing about, I think is really the central theme here. Fundamentally, my takeaway so far, after reviewing the record, listening to the testimony at the October hearings, and today, I think the department has filed its certification of consistency before it was ready to demonstrate consistency with the Delta plan. Today, I haven't heard anything that would compel me to think that the staff draft findings are going to change much before we take action in December. And again, we're not taking action today, but I'm particularly concerned about the issues related to flow objectives, reduced reliance, and Delta as a place. The goal here is to demonstrate consistency with the Delta plan's regulations that this body administers to further the co-equal goals. Political expediency is not the goal here for such an important and significant project. Frankly, I'm frustrated. This project came to us before it was ready. At this point, with the weaknesses identified, and obviously, in my opinion, there's more work to do, I would strongly encourage the department to consider withdrawing the certification of consistency. If you do so, choose to do that, let us know as soon as possible so we can resume early consultation. So members, thank you for your indulgence. Would anyone else like to comment? Frank?
Yeah, I would like to echo the chair's comments. We've heard a lot about timing, prematurity throughout this hearing and not only this particular workshop as well as the prior hearing. It seems clear to me that the record is not complete, particularly with key issues. And those shortcomings are precisely the areas where early consultation benefits everyone in this room. This is an adjudicative process. This is not a forum to work out shortcomings. That's not this purpose. It's adjudicative by nature. I agree that I think good government here the department should certainly consider withdrawing its certification and immediately resume early consultation. That said, all sides of this debate have a responsibility to find a path forward. All sides. All sides. No party believes that the status quo is viable. Reasonableness must, in the end, prevail. Thank you.
Thanks, Rick. Anyone else wish to speak? Okay, then let's proceed to public comment. If you want to provide public comment and are not a speaker on behalf of one of the appellant groups, the Delta Protection Commission, or the Department of Water Resources, we ask that you fill out the blue speaker card available from our clerk. Remember, the scope of the council's review is limited to whether or not the certification of consistency is supported by substantial evidence in the record. You may recall from this morning that the cards are marked in groups designated A, B, C, and so on. Your comments will be heard in the group order we received the completed blue speaker cards. We will start using the mic here to my left, your right. Please provide staff at the table with your completed card as you approach the microphone. We will now open public comment, beginning with Group A. In the interest of time, we also respectfully request that if you agree with comments made by a prior speaker, simply state that fact and add any new information you feel is pertinent to the issue. There is a timer located at the end of this table. Please respect the 3-minute time allowance. Additionally, I will not accept any request to cede your time to another individual. I urge the audience to extend the courtesy to all commenters and refrain from jeers and cheers. So with that, let's proceed.
Thank you. My name's Deirdre Desjardins, and the staff findings on sea level rise are based on my testimony. I had prepared a 18-point PowerPoint, but I guess it's not feasible to give that. The climate change analysis is not the best available science. It's not thorough, it's not objective, nor does it take into account the 2014 comments of the Delta Independent Science Board. For design of the project, DWR is assuming that there will be at most 18 inches of sea level rise in the Delta by 2100, with 55 inches of sea level rise at the Golden Gate. They got that from a very simple back-of-the-envelope calculation. 3D modeling by the U.S. Army Corps of Engineers, which I provided to them in comments, showed that 5.5 feet of sea level rise at the Golden Gate translates to an increase of over 5 feet in the Delta. Current best available science estimates of high sea level rise at the Golden Gate are over 6 feet by 2100, and NOAA says potentially up to 10 feet due to disintegration of polar ice sheets. If you're going to use 18 inches as an intermediate value, and that is within the 66% range, then why build a $20 billion project when you can just raise the levees? This is simply no way to design a $19 billion project to mitigate for sea level rise. DWR also eliminated use of the drier climate change scenarios to bound potential drying in the Sacramento and San Joaquin River watersheds due to climate change. All of their climate change modeling uses a central tendency scenario, and this does not match Western climate model well. It matches the East Coast in Europe, but not the West Coast, and they have eliminated evaluation under the drier scenario, which was proposed to deal with this regional climate modeling problem. I thoroughly agree with the staff's consideration that it's not the best available science on sea level rise. I would say it's not the best available science on climate change, period. And it's absolutely critical that this project get it right.
Nikki Seward with Snug Harbor on Steamboat Slough in the North Delta region. Thank you so much for the time to just speak briefly. There are a lot of us that went to all the WaterFix hearings, and I continue to be offended when DWR says things like what I heard today, that they were in compliance with water quality. If you look at the WaterFix hearing records, Mr. Patrick Porgins, he submitted a bunch of records of thousands of incidences when DWR were not in compliance with water quality in different areas of Delta. I also submitted evidence showing that there were times during 2015 when water quality wasn't met on Steamboat Slough because of drought situations and withholding flow. I submitted a lot of comments. My comments in WaterFix, it's SHR 701R for revised. My main focus has been what happens to our drinking water quality in the Delta. If you don't send down fresh water to refresh our aquifer, we don't have drinking water quality. There's already a change going on, particularly in Solano County, because of restoration actions and other things. And so I would request that you remand and say, please analyze impacts to us. DWR only provided evidence of impacts to a few wells along the tunnel pathway. What about the rest of us? We have a right to drinking water. I also submitted mitigation suggestions, including the community fund, prohibit use of certain roads in the Delta. And I also request that you look at what DWR proposed for residual flow on each of the 5 waterways in the North Delta. It is insufficient, and it suspends us if operated as they recommend. That's SHR 350 and 352. Please look at that, because it recommends splitting 5,000 cubic feet per second of the bypass flow between 5 waterways in the North Delta, and that's insufficient for keeping anybody water fresh. Thank you, and if you have questions, I'm going to be submitting more on this. Thank you.
Good afternoon, Chairman Fiorini and members of the council and staff. Thanks. My name is Steve Arakawa, and I work for Metropolitan Water District of Southern California as manager of Bay Delta Initiatives. And we've submitted comments, but I wanted to highlight some key issues for you today. Metropolitan disagrees with the staff determination regarding appeal of the certification of consistency. This is the most extensively examined infrastructure project in the history of the state, given more than 11 years of planning, tens of thousands of pages of analysis, and more than 1 million hours of dedicated staff time. The draft determination, staff determination, proposes unprecedented levels of new documentation and unspecified changes that are counterproductive to advancing the co-equal goals for the Delta. Since 2009, California water policy has called for all regions of the state that rely on the watershed to reduce reliance on this water supply to meet future needs by improving regional self-reliance. And Metropolitan has a long-term integrated regional water resources plan and an urban water management plan that demonstrates consistency with that policy. The council's staff draft determination suggests a lengthy delay in the review process, as about 200 Southern California local water agencies that may receive some of Metropolitan's state project supplies revise their water management plans to incorporate Metropolitan's overall plan to reduce reliance through improved regional self-reliance. DWR has provided thousands of pages of evidence that supports certification that water suppliers that will receive reliability benefits are improving self-reliance. In a separate determination, the need for California WaterFix was not significantly caused by any alleged failure to reduce reliance, but rather other factors recognized long before, and even in the Delta Reform Act, namely diminishing reliability of Delta exports due to more restrictive regulations to address declining fish populations, threats to delta levees, and climate change. In closing, the regulatory burdens and uncertainties surrounding the staff proposals are beyond worrisome for any proposal to advance the co-equal goals and address the unacceptable status quo. The council should refocus on the department's substantial evidence and direct staff to revise the draft determination accordingly. We think that there's an opportunity to revisit that documentation, and the council should not succumb to many months or years of paralysis by analysis. Inaction is doing not the Delta any good, nor the state of California. Thank you.
Chair, committee, members of staff, public. My name is Gary Kremen. I'm one of these 7 elected directors of the Santa Clara Valley Water District. Our district urges you to reject and deny these unwarranted appeals of the DWR certificate. A little bit about Santa Clara Valley Water District. We're the water wholesaler for over 2 million people in Santa Clara County in Silicon Valley. We do flood control, environmental stewardship. We're a county that is recovering from the Great Recession, full of people, disadvantaged members, a third Latino, a third Asian, who water rates are very important. This is our lowest cost water. We're doing things like recycled water, taking wastewater, bringing it to purified. That's $2,700 an acre foot. This is $600. Our citizens are seeing their water rates go up at twice the rate of inflation. 40% of our water comes from the Delta. We are doing these things like recycling. We're reducing our reliance. We've invested in the last 25 years over $300 million. It's similar to what our retailers are doing as wholesalers. Big plan, $650 million spend in recycling, but that is so expensive. This is our lowest cost water. We're not resting on it. We're doing a lot of conservation funding, et cetera. But despite all of those things, all of the above, recycling, other means, the Delta, we're dependent on it. And we're urging you, and we care. I mean, this project that when flows are high to be able to capture it, I think you need to, while you have your criteria, you need to look at this from a social justice point of view. Don't let wealthy Delta interests with shill environmental groups get in front of you and tell their story. Reality, at the end of the day, this is about the 20+ million people in California who depend on the Delta. Thank you for your service.
Good afternoon, Melinda Terry with the California Central Valley Flood Control Association. I was not planning on making comments, but after hearing some of the appellant's testimony and the comments by the chair, just want to add some things related to the prematurity topic. It's been mentioned, but the last conceptual engineering design we saw from DWR said it was only at like 10% design. That's very important because many of the components of this project, like building the intakes or 5 or 6 barge loading facilities, will all happen on levees. I believe most of them, if not all, are project levies that the state is responsible for. And to do that, you have to get permission from the Army Corps of Engineers, a 408. And authorization, and you have to be at least 60% designed to even do that. And as we've seen with the supplemental EIR, there have been changes to this project as they've gone from 8 to 10%. Well, actually, I would say it's also based on their listening to some of the comments, written comments on their EIR. You saw some of those alignment changes, some of the barge facilities moved, so it's different levees that will be impacted. My review of the chapters of the EIR and the construction and transportation appendices and then looking at their maps of where all of these facilities would go. And I'm including things like the muck sites in addition to the barge facilities, the intakes, a forebay being built, cement plants, fueling stations, all of those things. There was more than 30 reclamation districts when you looked at that full alignment that would have some level of impacts like that. So it's quite extensive in terms of the number of RDs that will be impacted. And some of those impacts as 13-year construction goes on can be quite significant. In order to construct, you actually have to dewater, so there are cofferdams and other things put in, and then they actually pump out that water to dry out the land to construct on. The chapters mentions land subsidence that really could occur from that. From a levee perspective, the vibration that will happen from millions of pile driving, as well as the road traffic that we heard about, a truck every 10 seconds, each truck making 8 trips per day. That's a lot of vibration, but on top of that, their transportation consultant only looked at 2 things. One was the traffic volume and the pavement. They didn't analyze what was underneath the pavement, which is the levee. I have spoken to the 2 engineering firms that do the levee work for more than 85% of the districts, the RDs. And they said, yeah, these were not designed by the Army Corps or constructed to withstand that amount of traffic. You will have serious degradation of the levee itself underneath. So for the RDs, you're talking a real increase in the operation that they have. But really, when you look at your policies, I want you to think about their ability to do their daily maintenance, for them to improve, whether it's to HMP or to Bulletin 192, and more importantly, for them to do their seasonal flood fighting when you have to compete with that level of traffic or those other things that are being constructed within your purview. And they just really can't operate with that level of disruption. I will say that there are ways to mitigate that. They've not really had good discussions and been approached on that, but there is opportunity to do that, and I appreciate your staff's recommending a remand, because there's a lot of these things that can be relooked at. Thank you.
Are there any more in Group A? Ready? Okay. Oh, we're on B? Any more on Group B? Okay, please proceed.
Good afternoon, Chair members. My name is Charles Dulac, and I'm a legislative aide here today on behalf of Assemblymember Jim Frazier. The Assemblymember would like to thank the Delta Stewardship Council staff for their thorough and accurate analysis of DWR's certification of consistency. The draft recommendation to remand the certification of consistency is the right choice for the Delta and for the Council. As clearly stated in the staff report, DWR failed to respect local land use, ensure reduced reliance on the Delta, comply with required Delta export inflow objectives, or utilize the best available science in preparing the California WaterFix project. These findings are consistent with arguments made by the 9 appellant groups, as well as the long-standing opposition of thousands of Delta residents, including Assemblymember Frazier. The tunnels project remains a travesty and an unjust proposed action against the residents of the Delta, which would create intolerable disruptions to the lives and livelihoods of Delta farmers, boaters, and community members. The arguments made by the 9 appellant groups and the Delta Protection Commission recognize this, and all of their recommendations ought to be included in the proposed determination. Assemblymember Frazier feels that the Council has no choice but to reject DWR's certification of consistency as out of compliance with the Delta Plan and the co-equal goals of the Delta Reform Act. Thank you.
Good afternoon, Karen Betters from Walnut Grove. I'm a Delta resident, and I wanted to take a few moments to thank the council staff for your preliminary remanding. It is very, very much appreciated by myself and a whole lot of people that are out working and don't have the time to come here or the ability to come here. And I do take exception to the comment of in Delta, wealthy grassroots, what have you. I'd like to know where they are, because I pay for myself to be here. And the idea that you're going to steamroll through the Delta, and that's what this is in its current form, is wrong. It's morally wrong. And I think it is. And then people sitting here on the side of the room, unless you live with the consequences of your decisions and pencil marks and ink on a piece of paper, you don't. And when you retire and you go away, you go off and do whatever it is the rest of your life is, but yet we have to live and deal with the destruction of a huge, beautiful geographic area that holds 80% of the state's prime-rated agricultural soils. It's just, anyway, thank you. I appreciate the preliminary, what you've done, and it's very, very much appreciated.
Thank you. Are there any other requests to address the council today? Seeing none, then we've reached a good point to pause today. Unless council members have anything they wish to, yes, Mike?
So, Mr. Chairman, I'm a little bit confused. We cannot vote on the remand action today.
That's
Is that correct?
It's
That's
scheduled for a council
scheduled for
meeting
December.
in December 20th and possibly the 21st.
But I heard two council members make the request that DWR withdraw their application. What is the practical difference between the two?
Well, in my estimation, based on what I've seen, withdrawing the certification of consistency would allow early consultation to begin. And that could begin sooner than if the council were to make a decision to remand the project. The alternative is to wait until December and see how the vote goes and go from there.
Got it. Okay. Thank you.
All right. Then thanks for all today's participants and attendees. Council members and staff are still subject to ex parte communication prohibition on this matter. This workshop is in recess. We will reconvene in this room tomorrow, November 16th, 2018 at 9 a.m. Thank you.